that was on there.
No, she didn't. She just told me.
Cody.
sounds like some people may have also gone to the wrong location.
Really?
Yeah. Okay. Are y'all ready to go?
We're ready.
Okay. Good morning, everyone. The time is 9:15. I'm Christian Waugh, the Special Master for Code Enforcement in Citrus County, and I call this hearing to order. We follow an agenda at these hearings. First item on the agenda is the call to order. I will apologize for being a few minutes late. I had read the agenda thinking that it was still at the courthouse in Inverness, although I was specifically told it was going to be here today beforehand. So in any event, I'd like to now ask you to join me in the Pledge of the Flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay, the next item on the agenda is approving or dealing with the minutes from the Wednesday, August 20th, 2025 hearing. Are there any proposed modifications, changes, or deletions to the minutes as currently formulated? Hearing none, I go ahead and approve them.
Staff update, abated and continued cases are listed up front.
All right. Thank you again, everyone, for your patience. My name is Christian Waugh. Basically, Citrus County has hired me to preside over your hearing today. What I'm going to tell you during this opening statement applies to each of your hearings, so I would appreciate it if you paid attention. When your case is called, please come forward, and you will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call its case, and I will allow the county to present its case. You will then have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and make legal argument. It is important that you take your time during this process because it is likely that you are only going to have one chance to make your case to me. I will ask whether or not you are contesting the violation. If you do not contest the violation, I'll assume a factual basis for the violation exists and proceed to ask you how much time you need to fix the violation or to work with the county. This will help save time for yourself and others, but you are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak. If there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, witness testimony should remain civil, and you should not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must abate the violation by that date, which means fix the violation, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county has the right to foreclose on that lien or to seek a money judgment against you after the lien has been recorded for 3 months. In addition, it may be that the county is requesting a one-time fine instead of a daily fine, and that would be for some kind of damage that the county considers irreparable. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose the costs required by county law. I incorporate these into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix a violation, you will be responsible for additional costs, as well as the cost of the lien imposed. You do have the right to appeal any order that I make today as may be provided by law. Thank you.
First case on the day's agenda, Wayne Arthur Wayrouch, case number 2025-975, Code Officer Alan Jonason, page 31 of your agenda.
Your Honor, I've been notified that this is a no contest by Mr. Wayreich. The parties have agreed on 60 days to cure and $100 a day thereafter if not brought into compliance by that date.
Can we swear him in?
Sir, Mr. Wayraj? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do.
Good morning, sir. What is your name?
Wayne Wyrock.
Wyrock? Okay, thank you and good morning. Did you hear what has been stated as the resolution between the parties?
Yeah.
And you agree to that?
Yes.
All right. Anything to say, Mr. Jonason?
No, sir.
All right, then I'm going to ratify the agreement of the parties. I'll find, for the purposes of the settlement, that a violation exists, but grant you 60 days to abate the violation, and if it's not brought into compliance as ordered, a $100 a day fine.
Okay.
Is there any member of the public who wants to speak on this case? I don't see any. So if you're not in my line of sight, by the way, I won't be able to see a hand raised. Just let me know. All right, thank you.
Thank you. Thank you.
Next case, Deborah Dowis, case number 2025-1281, Code Officer Julie Wilkinson, page 17 of your agenda.
Your Honor, I have been notified this is a no contest case. The parties have agreed on 45 days to cure and $100 a day thereafter if not brought into compliance.
Okay, good morning. I'll ask that y'all be sworn in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your names.
It's Deborah Swaggart now. Dowis is my maiden name.
Okay, welcome. Did you hear what's been said as the resolution? And you're okay with that?
Yes.
All right. Is there any member of the public who wishes to speak about this case? I don't see anyone or hear anyone. Ms. Wilkinson, does this comport with your understanding?
Yes, sir.
Okay, so what I'll do is find that a violation exists on the property on this case, but grant you 45 days from the date of the order. I'll issue a written order. And if it's not brought in compliance within 45 days, it'd be a $100 a day fine. Okay? All right, thank you very much.
Thank you.
Thank you.
Next two cases, William Guy, Encricteta, and Magala Perez Chapman, case numbers 2025-1300 and 1342, Code Officer Cody McGuire, pages 13 and 14 of your agenda.
Your Honor, I have been notified both of these are no contest. On both cases, 3 months to cure and $100 a day each if not brought into compliance.
Can I have you stand over there?
Sorry.
That's okay. Now you can all raise your hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your names.
William Guy Chapman.
Enriqueta Magali Perez Chapman.
That's it.
All right. All right, thank you and good morning. And did you hear the terms of the proposed resolution for your cases?
Yes, I have.
Essentially, 3 months on each case, I believe, to bring it into compliance. And if either of them is not brought into compliance, it would be a $100 a day fine. So for example, if 4 months go by, neither of them is brought into compliance, you've got $100 a day on each case. Does that make sense?
Yes, sir.
Yes, sir.
That's
Okay,
fair. That's more than fair.
All right. Is there anyone from the public who wants to speak on either of these cases? All right, Mr. McGuire, does this comport with your understanding?
Yes, sir.
All right, then what I will do is grant 3 months in each case to bring it into compliance, find a violation exists in each one. And if either is not brought into compliance as ordered, there'll be a fine of $100 a day. All right, good luck. Thank you.
Thank you.
Thank you.
Next case, Michelle Golly, case number 2025-950, Code Officer Erica Olson, page 20 of your agenda.
You skipped one. Vernon's and,
It's Burdenston?
Oh, yes, I'm sorry.
Contesting? Okay.
Yes.
I wasn't aware
I'm
of
sorry,
that.
Ms. Golly. So is Ms. Golly's contested?
one of hers is, one of hers
Okay.
isn't.
Right.
Then I'm sorry, ma'am. We're going
Sorry.
to get someone out of here.
Apologize. Next case. Bertingson, Anton Paul, and Sabrina Bertingson, case number 2025-252, Code Officer Cody McGuire, page 8 of your agenda.
I've been notified this is a no contest case. The parties have agreed on 3 months to cure and $100 a day thereafter if not brought into compliance.
Yeah?
Yes.
Yes.
We can discuss it.
Oh, yeah, that's fine,
Okay.
yeah.
Do you swear to
We'll
tell
find
the
out.
truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, and sir, what's your name for the
Hey,
record?
good morning, sir. It's Anton Berenson.
Okay, great. Mr. McGuire, again, good morning. So is that not what y'all agreed on?
I'm agreeing $100 a day. The only thing that I don't have is the time as of right now. Currently, it's in reference to shipping container. I am trying to, as soon as I leave here, I'm going to the permitting office. The last thing that I needed was a fill plan that I just got over the weekends. And I'm actually requesting a temporary use for construction-related services, meaning all my supplies and everything can be securely into there. So I'm basically asking for, during the duration of the permitting, 30 days after close is all I'm asking.
Does that make sense to Citrus County?
I didn't see any active permits. Are you applying for
The-
something?
What I just said is, after I leave here, I am going to there to get the only thing I have already a engineered drawings for my workplace. I also have the fill plan that I'm getting. I actually went over there in September 3rd or something like that, and I went to apply for a permit, which I got notarized, but I don't think they
Well, give
filed
me a
anything
moment
yet.
then. So is what he's saying making sense to you?
Is a permit for the pod or is a permit for something else?
The permit is for a workshop. It's a 30 by 45 building
Okay.
that I'm going to
So it does make sense?
It does make sense, yes.
And is
Thank
this
you.
achievable within 3 months to get the permit such that he can keep the container there?
All right, how long is it gonna take you to construct it?
I don't know at this point. Like, it all depends
May
on, it
not.
could
I mean,
take,
at the time that he gets a permit, isn't he allowed to have the container?
As long as yeah, I think that's realistic, especially since he already has the plans. Thank you, yes, I
Okay.
missed that part.
Well, so do you agree to, the reality is, it sounds like if you can get your permit in order and pull it, the case abates.
Yes.
That's what we think. So-
Correct, and
So
that's-
3 months is 2 months too many, right?
correct, yes,
So-
sir.
All right, so
So
you agree
I'm
with
hoping I can get the permit within.
So you haven't
today.
agreed, do you agree that I give you 3 months to go pull the permit so you can keep the container there?
Absolutely, sir.
Okay.
And then after that, then I just request that it gets abated until 30 days after
I'm not doing that. What I would do is find that the case goes away at the time
Oh,
that
okay.
you
Pull the
obtain the
permit.
permit and are
Oh,
allowed to
okay.
have the container. That's the way it normally works.
I understand. Yes,
Okay,
sir.
I understand what you're trying to do.
Okay.
I just, is there anyone from the public who wants to be heard on this case? All right. Then, not hearing any, I will grant 3 months to bring this property into compliance pursuant to the agreement of the parties, and it'll be $100 a day if not. All right? Good luck.
Thank you, sir.
Thanks.
Next case on today's agenda.
And I'm surprised you haven't announced Mr. Novich as an agreed resolution.
Not at this time.
Okay, all right, just check.
Michelle Golly, case number 2025-950, Code Officer Erica Olson, page 20 of your agenda.
Your Honor, as to the, make sure I get the right one, 2025-950 for Ms. Golly, which is the junk and debris case, the parties have come to an agreement of 14 days to cure and $50 a day thereafter for the fine with a no contest. As to the case ending in 940, that one's going forward as contested.
Okay. Can I swear y'all in?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, ma'am.
Michelle Golly.
Thank you.
Good morning, Ms. Golly. So let's handle the easy part first. That's case number 25-950. It's what I call the quote-unquote junk case. And it sounds like y'all have agreed that you should have 14 days to abate the violation, and then if it's not brought into compliance as ordered, it'd be a $50 a day fine.
Yes.
All right, and then let me first ask if there's anyone here from the public to speak to me about the junk case. I don't see or hear anyone, so I will go ahead and ratify your agreement. I'll find that a violation exists and give you 14 days from the date of the written order, and $50 a day if it's not brought into compliance, okay?
Okay.
All right, Ms. Olson, does that sound right according to the agreement?
Yes, sir.
All right, so we've eliminated that case, and then that leaves case number 25-940 regarding animals. So I'm going to let the county present its case.
Erica Olson, Citrus County Code Compliance Officer. This is case number CE 2025-00940. Land Development Code Section 3730 Alpha 1, Tack Animals. Number of goats exceeds allowance for acreage. The address of this property is 6456 West Meadow Street, Homosassa, Florida. The property owner is...
Goats? We're talking about goats?
Yes, we are talking
You're trying to
about goats.
keep people from having adorable, lovable,
Sir, hold on.
beautiful
It's not
goats?
me. It's not me. That's what the ordinance says.
Okay,
Just here to enforce.
okay.
The property owner is Michelle Gully. This is zoned RUR-MH and is 0.51 acres. I've got good service via signed certified mail return receipt and posting at the Lecanto Government Building. I'd like to authenticate the following items. Exhibit A, photos taken during my initial inspection on the 13th of June, my corrective action inspection on the 27th of June, and photos of my final inspection on the 15th of September. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the letter of continuation, and a copy of the signed certified mail return receipt for the notice of hearing and the notice of continuation, and a copy of the summary page from the property appraiser.
If you could, can you give me a narrative of what the violation is specifically?
She has 4 goats on the property, and it's zoned RUR-MH. You need an acre of property to have 1 goat.
So from the county's perspective, none of the goats are allowed?
Correct, sir.
How big is the parcel?
About a half acre.
It's half acre. And so, under the code, she would need how many acres to have 4 goats? Oh,
Miss-
4,
Miss-
right, because
Mr.
it's 1
Tim.
per acre.
Yes.
Right, okay. Sorry, I can't quite, if y'all need to talk, I would try to take it out. Okay, thank you. All right, then, ma'am, what we'll do is the county has some exhibits they'd like you to review for the purposes of the hearing. I'd like to ask you to take a look at them. Let me know if you have any objection to them being evidence in this hearing. There's a set of photos and a bunch of notices.
Yeah, that's my house, my goats, yeah.
Okay. Do the goats have names?
Yes, they do.
What are they?
It's Sister, Mackenzie, Alistair, and Chrome.
Chrome?
Chrome.
Hmm.
She was born with chrome coloring on her, but she's outgrown that.
Hmm.
I guess these are notices that was sent to me. Some of them made it, some of them did not, so I think I ended up with like the 3rd notice. That's okay.
Okay. Then without legal objection, I'll admit exhibits A and B as evidence and take a look at them.
I also have a letter of ESA about the goats.
And we'll get to that, so I'm glad you let me know. What I'm going to do is first I'm going to let the county present its case, and then I'm going to ask you, well, you'll have the opportunity to cross-examine them, but after the county's done with its presentation, you have the chance to give me whatever evidence you have, and they'll take a look at that. First, I just want to see the photos so I can kind of wrap my mind around what's going on. There they are. How long have you had them?
The 3 younger ones are 6 months old. They were born in February at the house. And sister I've had
They're
for-
6 months old?
Yeah.
Wow.
And then sister I've had for 2 years.
Okay. All right, please proceed with your case.
On June 13th, 2025, I conducted an inspection at the above referenced address in response to a complaint regarding a violation of the Land Development Code mentioned before. During this inspection, I observed 4 goats. being kept in the backyard in violation of the applicable code. A corrective action inspection was conducted on the 27th of June, at which time the property remained in violation. On September 15th, I performed a pre-hearing inspection and again found the property still in violation of the same ordinance.
Okay. Ms. Scully mentioned a letter. Has that been presented to you?
Yes, I received that on Monday morning.
And what is the county's position on that letter?
I'm going to refer to the county attorney.
At this time, the county's position is we did receive the letter. However, the goats and their living situation do not meet the requirements for an ESA exception within the statute.
Okay. Do you have any questions for Ms. Olson?
No, I would like to know what requirements are needed for the ESA. I mean,
I do want to, we'll get into that. But that's more related to your defense and what their case is, so I'm not quite there yet.
okay.
Ms. Coutu, are you going to testify on this case? Or?
If you need me to, she cited the code. It's 1 acre and 1 goat per acre if you have an acre in RUR.
Is this something that the county either can or has issued like variances for or exceptions or I don't know what's available.
Right, not for the land use, the minimum, there's a exception possibly for a conditional use to try to exceed the numbers, but in this case, it's a half acre, so I don't know how likely that is.
Unlikely to be granted based on the space. If it was like 2 acres, maybe.
For a goat
for
or
4
2,
goats or 3.
right, it's
yeah.
supposed to be 1 acre per
Right.
goat. Yeah.
Now, just to be clear, if she had 1 acre, she could have 1 goat in that zoning.
In this zoning, correct.
Okay.
And
Thank-
Ms. Coutu, under the land use code, are goats allowed as pets? Are they classified as pets?
Right, we have an exception in our code for certain animals outside of the residence, but goats are specifically one of the prohibited ones. I know you like those, but.
Following animals are specifically prohibited from being considered personal pets under this section and are allowable only under the provisions of this LDC within residential districts. Roosters, gamecocks, turkeys, geese, peacocks, guinea fowl, ratites, parrots, horses, cattle, goats, and sheep and swine. It seems pretty clear. Man, what a shame! I just have to say. I mean,
know you like goats, yeah.
Because
we don't hate goats either. It's just the acreage.
All right, so I'd like to talk to you, Ms. Gawley. So that's we know what the county's case is. They're saying that look, under this zoning, you don't have enough space, that even for 1 goat. And if all else were equal, it appears that they'd be correct. But you have a defense. So what do you want to tell me?
I mean, by Florida state codes, I mean, I have more than enough space. And you can't just keep 1 goat by itself no matter what. So I really don't understand why the code is even 1 goat per acre, because that's just ridiculous.
Well, this is an example of something that if, like the words in this law are very clear, whether anyone likes it or not. And if y'all want to change it and you can inform the county commission, that's up to you to kind of seek an amendment or anyone, watching. And there have been amendments. In the time that I've been the special master, there have been several amendments to the code that I think have been for the better. So at any rate, but you mentioned thinking that an exemption applies. I want to talk to you about that. I mean, what exemption is it? And I'd love to see your letter if possible.
I have the letter here for the ESA, and I don't understand what it is that, I mean, what needs to happen to have the ESA work, because, I mean, ESA is ESA letter. They aren't a nuisance. They don't make a smell. The only time you hear any noise out of them is when it's dinner time. All the neighbors that are actually connected to my property love them, come over and ask to feed them. I just don't know what I need to do here. I mean, I bought this property particularly because I had the goat, and I was told that goats were allowed there. There are goats in the neighborhood. Not all of them have an acre per goat, and I don't want to write anybody out on that, but it's ridiculous to me, because unless you really, really search for the codes concerning goats. It's very hard to find.
Well, let's talk about the exemption. So I'm not ruling on it yet. I don't exactly know what's being claimed. So if you could, do you want to introduce this letter as evidence in the hearing?
Yes.
All right, then I ask that you show it to Ms. Olson, and they'll take a look at it. Apparently, they've already seen it, but I haven't. And I'll give them a chance to make any objections they want, but
Yeah, it's the same letter. Okay.
any objection?
No objection.
Okay, then without objection, it's being received as Exhibit C, and I'm going to take a look at it, and it may just take me a moment. Are you sure you want this to be public evidence? Okay,
I'm
all right,
fine with
that's
it. I
fine.
mean,
I just
if
want to
that's
make
what I
sure
have
you
to do to-
understand. Okay.
If that's what I have to do to keep them, yes.
All right, so let me first talk to the county about it. So why does this not, I want to remember exactly what your point was, that it doesn't meet the conditions of an ESA?
Under Florida statute 760.27, in order for an individual to meet the qualifications for an ESA, the person has to indicate that they have the physical disability, or actual, not physical, but it could be alternative. And also the animals have to reside in the dwelling of the individual. These animals reside outside.
So it's the county's position that based on the Florida statute, there can't be an ESA that resides outside.
Correct.
They do come in the house sometimes. So I mean, would I have to
I
keep
accept
them in
that.
24/7?
I accept that, but I also accept that they don't live inside. I mean, they're goats. It's interesting, but I'm going to take a little time to, can you give me that statute site one more time?
Yes, it's 760.27. It's sub 2.
Okay, sub 2. I'm trying to get on your Wi-Fi.
It's very horrible. Would you like me to approach with
Normally it's good. I mean, I've never had any trouble logging in before, but do you have a, oh, hold on, let me get it. I got it, okay. Well, let me just say, I don't agree with the county's interpretation. I don't think it's dispositive of the issue, but in Subsection 1A, it defines an emotional support animal as an animal that does not require training to do work, perform tasks, provide assistance, or provide therapeutic emotional support by virtue of its presence. So it's not, and the definition of an ESA is not limited by whether it can be inside of a dwelling. Now in subsection 2, what it states specifically is, it is unlawful to discriminate in the provision of housing to a person with a disability or disability-related need for and who has at any time obtains an emotional support animal. A person with a disability or disability-related need must, upon the person's request and approval by a housing provider, be allowed to keep such animal in his or her dwelling as a reasonable. So I don't even read that as saying that it has to be in a dwelling. I read that as upon request, they have to be able to keep it inside the dwelling. But I also don't think the county is a housing provider. This is a zoning law.
Correct.
This is a zoning restriction, and I don't know that I just don't know that this statute applies to give an exemption to a zoning code. What this does is it allows a tenant or someone to keep an ESA on the property that they get from a landlord. So I'm having a hard time. I think this is an ESA. I accept this letter as evidence that the goats are ESAs, or at least sister for sure. So my struggle is that this is a matter of first impression to me in terms of applying the ESA relating to a zoning issue, and I'm not prepared to rule on it at this time. So what I'm going to do is continue this to the next hearing. Sorry to have to make you come back, but I'm just not prepared to rule one way or the other on it. I think this is an interesting legal issue from my perspective, and I want to get it right. So I may issue a briefing order. I may not need one, but I need to look into this further. Okay?
Don't forget about the public.
Yeah, actually, you're right. Is there anyone from the public who wants to be heard on this case? That's true. Thank you. Come on up.
Ms. Golly, can you?
Yeah.
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Your name, please.
Michael Novich.
Thank you.
Thank you.
Good morning.
Good morning.
I'm shocked and also not shocked that the issue, before us regarding these emotional support animals is on today's agenda. And I think it's really something that should be immaterial. I think that how people handle their problems, provided they're not bothering and victimizing and creating chaos in our society, is appropriate. I know that you're taking your time to look into it, and so we, the people, thank you, Christian. But from my understanding, for the emotional support animals, which are separate from service animals, the emotional support animals, to my understanding, provided that they're actually handling unique, specific problems, they have merit. And why that would not supersede local municipal code it's enough to put me in the grave, and I'm 32, so we really need to try to start thinking, having some judicious angles. I know that zone is what it is, but this is someone's health. There's no problems here. We need to move forward. That's all I have to say.
Thank you, sir. Is there anyone else from the public who would like to be heard?
I just had one more comment.
Sure.
ESA is not just for housing, it's also for traveling, like if you're on an airplane or otherwise, as well as staying in a hotel, which is definitely not zoned for, animals. So it's not just a housing issue with the ESA letter. It is, overall.
I understand. I mean, I'm going to look into it, but that statute does relate to is only a housing issue. So that's why I brought that up. So, no, I will look into it, and I may want to hear from you and from the county in the interim to help me better understand the issues. All right?
Okay.
Thank you.
Next case, Rodney E. and Benjamin R. Spath, case number 2025-1238. Code Officer Cody McGuire, page 28 of your agenda.
Isn't it also 29? Are we not doing 29
If it's
at
the same
time?
address.
They are the same address, two different cases.
However y'all want to do it, it's fine by me.
See if Cody's comfortable with them together. Are you good with running them together? Or do you want to do them separate?
Yeah, I can do them together, but there's different dates.
Whatever works for y'all.
I think we should do them separate.
Okay.
That'll work.
Which one first?
We're doing 1238 first.
Thank you.
All right, so that's page 28 of our agenda. Good morning. I'd like to swear you in.
Gentlemen, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your names.
My name is Rodney E. Spath.
Benjamin Spath.
Thank you.
Okay, thank you. Mr. McGuire?
Yes, sir. Cody McGuire, Citrus County Code Compliance Officer, case number 202501238, a violation of Citrus County Land Development Code, section 4002, site development without a development order or permit. The address is 9187 North Cavewood Avenue, Christopher, Florida, 1.16 acres, and it's zone CLR. The property owners are Rodney E. and Benjamin R. Spath. Good service via posting the notice of hearing on the property and at the Lecanto Government Building. And I would also like to authenticate the following documents and request they be admitted in evidence. Exhibit A's photos I took during an initial inspection on July 21st, 2025, corrective action inspection on August 22nd, 2025, and photos of my pre-hearing inspection conducted on September 15th, 2025, and aerial photos from the property appraiser's office dated 6/6/2023 and then 5/5/2024.
All right, can you tell me a little bit about what the case is about?
Exhibit B.
Oh, and then Exhibit B is a copy of notice of violation, notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property, and a pre-hearing order.
Thank you.
And so basically what happened is they had cleared out the majority of the trees and brought in a large amount of fill and spread it out through the front portion of the property.
Okay, that helps me understand it. Mr. Spath and Mr. Spath, is it Spath?
Yes.
Okay. I'd like to ask you to take a look at these documents and let me know if you have objection to them being evidence, the photos, the notices, that kind of thing.
I don't even want to look at them.
Okay, you don't have to.
The notices, though, this was the wrong address. We didn't receive any of this stuff until our neighbors seen this on our gate and called us and told us, and we were both out of state at the time. We come back into state just to take care of this matter because we didn't know anything about it.
That's a
'cause
fair
they were-
point to raise.
They were sent to the wrong addresses.
Well, it's the address that's on the property appraiser website for the property. So that is the right address under the statute. And if y'all want to get it at a different
This
address,
has an address that says Clearwater. That's not the correct address.
is that not the address on the property appraiser?
No,
Okay.
no, this is my address in Clearwater, not my address in
All right, we'll check,
Clearwater.
well, then we'll check on it. Now, I'm going to make an academic point and a practical point. And this is for everyone's benefit. The academic point is you are here, and therefore it doesn't matter. Okay, I'm not trying to be cute about it, but usually there's a
Well, we didn't get the first
Sir, if you would,
notice,
just I'll get to it. But like
Quite a minute.
the reason why I'm saying this is because the point of notice is to make sure that you know what's going on. You don't want me to rule without you being here, right?
Sure.
So that's the point. And so the fact that you're here means if there was a mistake, I'm not going to find that the case gets thrown out based on. Now, as a practical matter, I agree, and we want to check and make sure what the right address would have been. So I appreciate you telling me. Have you researched it?
I need to see the documents, to know
Okay.
which page,
Then-
which numbers they're talking about.
Let's see what Mr. McGuire has, and they said they don't want to see it.
I don't know why
Cody.
you need to see
Okay.
it, 'cause you took
Yeah, Mr. McGuire,
pictures.
it's okay.
I mean, you know, pictures are pictures.
So we're going to look into that.
The address on the notice is the one on the property appraiser's website,
It's the Clearwater address?
1433 Morrow Drive, Clearwater, Florida, 33756.
So, sir, that's the issue. You have to change the address with the property appraiser because they are allowed to send notices to that
I
address.
never received a notice to this address is my problem.
Oh, you're saying the address is right, you just didn't get a notice.
Well, it was, but we moved shortly ago, and all our mails forwarded to my new address in Clearwater, but we never received it, period.
Well, that may be a
never
problem with
received nothing.
forwarding. I don't know, but I understand what you're saying. It's just, they have evidence that it was mailed to that address. So, but let's get into it. So let me just take a look at their photos and evidence. I want to understand what's going on. Site modification without development order.
When was the date that the pictures were taken?
We'll talk about that. Let me just take a look. All right. Protected by the Second Amendment, good. Okay, so sir, your question was when are the photos taken? And I have dates of July 21st, August 22nd, and September 15th of this year. And then the aerial photos from the property appraiser. Mr. McGuire, you had the dates handy, didn't you?
Yes, sir. They were, it was June 6th of 2023.
I see that, June 6th, 2023, and May 5th, 2024.
Yes, sir.
Okay. So go ahead with your case.
Okay. Let's see. I conducted an initial inspection on July 21st and know that the property had a large amount of the trees removed and groundwork done. A notice of violation was issued for site mod, which is a violation of the ordinance listed above. While researching the property, I noticed that there were no permits applied for or issued. On August 22nd, a corrective action inspection was conducted, and there was still no permit applied for or issued or changed to the property. And as my final inspection on September 15th, no permit has been issued or applied for.
Ms. Katu, does that comport with everything you would testify to?
Yeah, it's a little over an acre residential lot, but we have no applications. It should be vacant.
So as far as you know, there's no permit pending or anything like
No
that?
applications
Okay.
as of yesterday.
All right, thank you. So Mr. Spath, I'd love to hear from you on this.
Well, first off, I guess I don't understand why in the heck anyone would even own property to start with. You know, this is supposed to be a land of the free, home of the brave, and on and on and on. You know, Constitution that's supposed to be protecting our rights and stuff from things like this happening, as far as I'm concerned. But yet, you gotta bow down and kiss everyone's hind end to be able to do something so stupid as take down trees that are bad, that are fallen, that are dead. You know, we had the property ground down, and then we had to have excess get in there, so I put in my culvert. I called, and they said, well, you gotta have a galvanized culvert. So I went and bought a galvanized culvert and had my driveway put in, you know. So I got access to my property so I could clean it up and make it look respectable, you know. And then, yeah, I ended up, we had to move from where we were at. The landlord was raising our rent exceptionally high, and so the place that they found was too small. So I got the container and moved my stuff in there so I'd have somewhere for my stuff, because I sold my house in Ohio. You know, now I gotta have someplace to put all my stuff, you know, because we was planning on building, you know, and then just, I was up there cleaning up the property and stuff, you know. I mean, and as far as these notices go, I mean, I wasn't even in the area after, what, June 13th, 14th, something like that, because I go to Ohio to work. I don't come back till Thanksgiving time, you know, and so we just closed the gate and said, I'll be back.
How big is the property again? It's an acre or so?
Over an acre.
Over an acre, yeah.
Acre 1.6 or something like that. And so, I did come in and ask the lady about the fence height and stuff like that before I put the fence up. She said I didn't need a permit for that, the way I understood it, so we secured our property. you know, and, but we haven't been there. I'm not living there. I mean, I don't, we start clearing the property off. We, like my son said, we've been gone. And if my neighbor had went by and seen this posted on
Wouldn't
my,
even have been here today.
out beside my mailbox, I wouldn't even know anything about it, because, like it says, the stuff wasn't sent to him. And if you're not supposed to be living there, you know, a lot of people don't show up to their property for 6, 8 months at a time, you know, because it's Florida, you know. And so here we are, you know, but we have started to move everything off the property. We got a container moved, you have cleaned the container out over the weekend, got the container finally moved yesterday.
Which is going to be relevant for your other case.
And we have everything else ready to move out today.
Yeah.
To finish up, because he had business to take care of in town in Clearwater, so I've been up here working day and a half by myself, trying to get
Everything's squared away.
all this stuff taken care of before we had to come in here today, but it's just too much to have to get done.
What do you intend on ultimately doing with the property?
We were planning on building,
Yep,
but now we're not so sure.
I mean, if you're gonna be throwing rules and regulations, and you have to kiss everyone's hind end to even get anything done, and then the people we're talking to are saying, well, you know, we was just talking to one business that said it took them over a year to get permits to clean out their building,
After the storms from last year.
to be able to even do anything that they need to do to get back in business. So, I mean, if they're treating their business people that way, it takes them a year to get the building back open, because they can't process the permits and stuff fast enough. I mean, it's a business. I mean, so how are they gonna treat an individual to try and get something done? Because I just did down the road talking to my neighbor. You know, he says, I got my permits and I got this and I got that. And he says, no, I gotta take my stuff off the daggum property too. He says, how am I supposed to build? I mean, he got his fill in and block laying there and stuff, and now they're making him haul a bunch of his stuff away. I mean, where does it stop at of people putting their nose in a lot of times that they shouldn't be? I mean, people, you know,
Or just the point of owning property is to be able to enjoy your land, go to your land, you know what I mean? And there's no enjoyment in this at all. If you can't go and enjoy your property and work on your property, then what's the point of owning property, period, then?
I mean, I'm 76 years old, I'm still working because I wanna have something, and then all I get is kicked in the hind end for everything that you wanna do to improve the neighborhood, when the neighborhood looks like crap, a lot of it. You
This
know,
house is full of trash everywhere.
why
and all
aren't
kinds of
they
stuff.
enforcing the stuff like that?
Are you both
instead-
from Ohio?
Yeah.
Yes, I've
Have
been
you
in
ever-
Florida for 10 years.
Have you ever heard of a town called Euclid, Ohio?
Yep, I
Yeah.
know where you go up by Cleveland.
No kidding.
I drove truck all my life, so you can rattle off a town. and
Yeah,
the
well,
chances
then
are I'll
you've
probably
forgotten
know.
more about every state than I'll know about any. But I ask about Euclid because there's actually a very, very famous Supreme Court case, and it's called Euclid, all right? And it came in the 1920s, and what the Euclid case did is it ratified by the Supreme Court of the United States the idea that you can have these kinds of zoning restrictions. And it changed the course of land use in America from Florida to Washington State forever.
Yeah.
And it enabled counties to create these rules for you. This is what I do once a hearing.
It's called control.
Well, but you
Control.
your knowledge of these things is imputed, because otherwise the system wouldn't work.
Yeah.
And so I understand, believe me, I understand what you're saying, but it doesn't change the fact that your democratically elected representatives in Citrus County have long ago adopted these things. And you're not the only one who's going to be here today who's going to say, I believe in America, I believe in the dream of America, and
Yeah.
you know, I thought that with a piece of property I have a pie of rights, but now I'm finding I just get a slice. right? So
Not
instead
even
of,
a slice, not even a
well,
slice.
so
Get the crust
instead
left
of,
on the edge.
I can do, well, there is a city that doesn't have this kind of zoning, and it's Houston. And a lot of people hate it because they say, oh, but there's a commercial next to a residential and this and that. But what's interesting about Houston is it does somehow work. So there's different models for this, but this is the usual. And everyone here is going to be held responsible for if it follows the code or not. Now, here's the thing. Your second case, going to be held today. That's what I'm going to hold because that's what the code says, whether I think it's a good idea or not. My job, apply the law. Does that make sense?
Yeah.
And I want y'all to read that Euclid case. Look it up.
I'm
Euclid,
going-
Ohio.
I'm gonna look it up. I will look it up.
What's the county's recommendation on this case? And we'll get to the public.
A county recommends a fine of one time of $5,000.
Okay. Let's hear from the public. Who from the public wants to speak on this case? I see a couple hands, so we'll get to Mr. Novich first.
Good morning.
Good morning. You've already been sworn in.
Cool. I don't know if I'm allowed to cross-examine, but
You are not.
if we don't have proof of what species were taken down, I mean, I'd imagine camphor and Chinese tallow just dominates these parts. It's all invasive species because on the walls is a bunch of posturing. Okay? I went over that last time. I don't know who needs to scrape it off the walls. I'm willing to do it. We'll get to that in my case. But it sounds like some hardworking guys from out of state probably removed a bunch of invasive trees here in Florida's Nature Coast. Appreciate the work, guys. Yep.
Thank you, Mr. Novich. I did see one other hand. Ma'am, would you like to come up?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Melissa Craddock.
Thank you.
Ma'am, please proceed.
I have nothing to do with their case, but I just wanted to speak up because I have developed 2 properties in the last 2.5 years. According to the codes that I have found in Citrus County is you can remove trees if they are under 4 inches around, if they are dead, diseased, or, like he said, invasive. So you can remove those without a permit. So if they were acting and removing those trees under those conditions, I could see where they could have those done without having a permit, according to the county.
Thank you, ma'am.
You're welcome.
Is there anyone else from the public who wants to be heard on this case? What's the county's response to the point about the trees? I mean, I understand the case is more than trees. I understand that it includes fill, so that would still be irrelevant. But I do want to know, what's the evidence on the trees?
You want me to? So with the aerials, it looks like 4 inches. They're not under, there might be some under 4 inches, but it doesn't look like there's many. As far as the dead and diseased, it's not just that it's dead disease, I can take it out. You actually do have an arborist. You have to have somebody certify that they're dead and diseased and they're a danger to property or humans. So it's not just I go in and clear. It doesn't work that way.
Okay.
So when there's no needles, no leaves, and branches are falling off, it's not a dead tree?
So you would be interested to know that in many cities and counties in the state of Florida, in order to prevent the owners from being their own arbiters of what is a perhaps dead tree or otherwise, you have to get a licensed arborist to certify that and let the county know that is in the Citrus County Code.
There again, the average person that works his hind end off gets screwed again. Because now you gotta pay someone to come out and say, oh yeah, your tree is dead and limbs are falling on the ground.
you know, the flip side to it
I mean,
is,
you got trees going this way and that way because they've
Wind
been
blowing
twisted
over,
a much
trees
and
blowing over from
they're broken.
storms.
well,
I
you
mean, it
know,
makes no sense.
there
I mean,
are,
It's about money, that's all it's about.
well, it's, the county commission passed all these things, you know? So, I mean, ultimately, you as the citizens of Citrus County have a responsibility to, you know, if you don't like that law, to change it, because this is, they have the task of enforcing these laws. And I don't know if someone complained or otherwise, but, you know, that's how code works. There's gonna be some laws that people do like being enforced, of course. This is one of the less popular ones, but it's there. Now, Citrus County, well, so you already gave me your recommendation, correct?
Yes, sir.
I'm gonna ask one more time. Is there anyone else from the public who wants to be heard on this? All right. How big, it's over an acre?
Yeah.
1.16, so 1 1/6.
We were working on going to build a barnuminium. That's why
There's plenty of room for
And
one.
and actually, there were more trees cut down by Duke Power that were actual live oak trees. They cut down to put in the service down our road to the end. They come through and cut like 5 or 6 live oaks on the front of our property down. We have no trees across the whole front of our property
I have
now.
never met the utility company that liked trees or property rights, so.
I know, that's what I'm saying.
But at any
They cut
rate,
down as many trees as we did almost.
and the ground.
So in order to
about
remain
20
consistent,
feet.
we have a lot of these cases. So there has to be a deterrence value to following the code. I will assess a fine of $2,000, not $5,000, and that's it. And you can appeal it as well. So there will be an order
It
to that.
cost me more money to take off work to have to come back down here. Because I've already lost $1,000, just had to come down here and then pay someone to move my.
Oh, let's go on to the next case.
You have
Help
one
move
other
my
case.
stuff.
Let's go on to the next case.
Next case, 1239, Code Officer Cody McGuire, Rodney Spath, Benjamin R. Spath.
No, you haven't. I'd like you just to tell me what the case is, if
Okay.
you would.
Page
Absolutely.
29 of your agenda.
Thank you.
Case number 20251239. The address is 9187 North Cavewood Avenue, Christopher, Florida. Property owners are Rodney E. and Benjamin R. Spath. And a narrative is what you're asking for?
Yeah, what's this case about?
They're just storing their items that they had mentioned prior on the property. Their Connex, their RV, car, trailer, odds and sods.
All right, so in other words, we have a code section that says if you have a vacant piece of land, what's the zoning on this?
CLR.
CLR?
Yes, sir.
All right, so without the primary use established, they can't use it for accessory uses, whether it's storage or otherwise, correct?
Correct.
No camping,
Correct.
no picnic tables,
Correct.
that kind of thing,
On your own property?
until the primary use is established. And so this is code section 3102. But I just want you to understand. Now, it sounds like you've already started removing things from the property.
We'll have everything off today, pretty much.
Well, and I understand that you probably think you've already answered the question I'm going to ask, which is how much time do you need? But when I ask that, I mean, be sure. Like, how much time do you
How much
need
time can we have?
in an
We'll try
abundance
to
of
get as
caution?
much done as we can, but we also need to leave as soon as we can to get back to finished work.
Yeah, look, I mean, I've got photos from 2 days ago, and what I see are,
Probably us moving stuff, probably.
yeah, I mean, I see vehicles and a trailer.
Yeah, because we're loading and moving
Yeah,
and everything
I don't see a
else.
lot of miscellaneous stuff and junk, so I mean, I don't see a lot that isn't mobile,
Yeah,
right? So,
everything's mobile, yeah.
all right, so if I gave you 10 days, would that be enough time?
Yes.
Yeah.
What's the county's recommendation?
$300 per day.
How much?
300.
Is there anyone from the public who wants to be heard on this case? All right. I will find that a violation exists. I will give you 10 days to bring it into compliance, and $100 a day if not brought into compliance as ordered. Okay?
After that, after the 10 days?
Correct. Correct. There's no fine until that time.
Okay,
Thank you.
Thank you.
thank you.
Next case, Mark and Catherine Irene Riddle, case number 2025-806, Code Officer Alan Jonason, page 26 of your agenda. Expert witness on the case, Land Development Director Joanna Coutu.
Hey, good morning.
Good morning.
I'm Mark Riddle.
Thank you.
Yes.
Alan, did I speak with you?
You did?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir.
And you are Mark Riddle.
Yes, I'm Mark Riddle.
Any relation to Tom Riddle? I bet you've heard that before.
No.
No? Okay.
No, who's
All right.
Tom?
Yeah, he's bad news. So we usually don't speak his name if we don't have to. But that's a long story. So
Okay.
all right.
Yes,
Please
sir.
proceed.
Alan Jonason, Citrus County Code Compliance Officer.
Sorry, Mr. Jonason.
This is case number 2025-00806, Citrus County Land Development Code, Section 4002, Site Development Without a Development Order or Permit. Address of the violation is 4286 North Carl G. Rose Highway, Hernando, Florida. Property owner is Mark Riddle and Catherine Riddle. This property is roughly 1 acre and is zoned MDR and was purchased on 15 November 2024. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 29 May 2025, and aerial photos from the property appraiser's website dated 7 May 2024 and 23 June 2025.
What was that last date? 23 June?
23 June
Okay.
2025.
Thank you.
There's 2 aerial photos.
I got it.
Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the certified return mail receipt, and a copy of the pre-hearing order.
All right, actually, can you give me a narrative of what's happening on the property first?
Yes. So what happened is, it appears that trees were removed, the property was graded. Now, the property owner initially put up a pole barn, has since taken the pole barn down, has removed all the items from the property, but the site modification violation, obviously.
Did you have other cases pending? Or
I did, and
Those
there was
abated.
a shipping container on the vacant property, but it has since been removed.
Those abated?
Yes, sir.
And so you've had contact with Mr. Riddle?
Yes, sir.
Okay. Now, I'd like to ask you to take a look at these documents and let me know if you have objections to them being evidence in this hearing. In other words, there's going to be some photos and some notices.
Yes.
Okay. Just so I know, is there anyone from the public who's going to want to be heard at this point? All right, maybe. Reserve the right. Thank you. What's been proposed as Exhibits A and B are evidence, and I will just take a look so that I have an understanding. So I see that back in May, and this is a little over an acre?
Yes, sir.
Okay. All right, let me look a little bit closer here. I see. Okay, so what it appears based on the photos is that, Mr. Jonason, you started this case May-ish.
Yes, sir.
Got some photos. Property owner worked with you, took the pole barn down, and then by the time the second aerial was taken in June 23 of 25, the pole barn was gone.
Yes, I'm not sure the date the pole barn was actually taken down. I just know between 29 May and I want to say the first part of August, maybe.
Well, I'll
it
tell
was
you it's
gone.
down on the June 23rd photo.
Okay.
So
Then between May,
that would be pretty
29
quick,
May.
pretty quick
And-
action.
And initially, I had cited the wrong address, and I have that in my, my information to speak to you about. I had cited the wrong address, and I had spoken to the property owner, re-engaged and sent the correct notices to, for that property. He also owns property next to it as
I got
well,
it.
So,
Well, I appreciate your candor. Mr. Riddle, so you've heard what the county's case is. What would you like to tell me?
Well, I live in Oregon, and I'm only here part of the time. And so I bought this place, and I needed a place to store my things. I like to have, so I called, I got a hold of this friend, and he puts up fences and he does pole barns. And I says, what do you need to do in Citrus County, for a pole barn? He says, well, you can just put one up without any permits, and if you put up concrete in it, you'll get in trouble. You have to wait for a year or two till they go away. It says, oh, okay, that sounds good to me. So I went and I put up a pole barn. And then on my gate, I got this notice, and it was from Tim Williams. And it said, stop work order was a illegal structure. So I don't mess around. I got it done. I'm not asking for more time.
Yeah, you did it quick.
I just got right on it.
Yeah.
And it broke my heart, and I tore the bill, I took it away. And so then I called up Tim and said, it's done. Got it all done. So then I went to Oregon, 3,700 miles away. Then my neighbor calls me and said, hey, they put this big old sign on your property there. And so he took pictures of it and sent it to me. So then I had to make a special trip here to be here today. I've taken out the container box, done everything you say. I just beg for mercy on the
random lawyer sitting here. Yes. All right.
Because I came down here and tried to, when I got this, I came down here and I talked to this guy here. I talked to 3 different people, and they said, no, you can't have the pole barn.
Right.
You cannot have, you have to have your initial structure first. So usually when you get in trouble, money fixes everything. Not this time. I had to take my building down and take it away. Anyway, I'm very discouraged. I don't know what to do with the property. I'm an old guy. I just wanted to put up a pole barn. And I was gonna build a house there eventually. And when I was working, the neighbors stole my tools, so I put up a box to keep from losing my ladders and things. I'm just very discouraged with the whole situation. Right now, what I want to do is I want to mow the grass. I don't even know if I can mow the grass without getting in trouble. I want to put it on the market, I want to sell it. I'm done. And I would like to just say goodbye, and you guys leave me alone, and I'll leave you alone. Is that a plan?
It might be, and it might be that money solves this, but we'll see. What's the zoning on the property? What's the zoning?
MDR.
And so he can't, as a special or conditional use, have a pole barn or anything?
I'll defer to Joanna Coutu.
Yeah.
No, he can't. You need to have a principal structure, some kind of residence. It's MDR, so not a mobile, but a house, for sure.
Okay, but if he did have, and it sounds like he doesn't want to be here anymore, but if he did have a residence, it's possible he could have a pole barn?
Yes, right. And these are all citizen complaints. This is not something the county just picks up on.
Correct. By law.
Okay, I understand that.
Okay, no, I just want to make sure that,
But the way this was handled, and, in pieces, and they didn't just get a hold of me and tell me, this is what you want, and I go do it. They told me to do this, then another time he tells me to get rid of the box, and another, it's not all, it was handled very poorly.
Well-
And they didn't even put the right address. So how am I gonna respond to this? How am I gonna go get a permit or try to get a permit? Which should I get a permit for, this address or that address? Very confusing to me.
well, I don't know. I will say that I think the issue before me is very clear. In other words, yes, there's been some clearing on the property,
Yes.
undeniably, right? And that's a vestige of the pole barn that you thought you could have on the property, because someone told you that. this is a cautionary thing for anyone watching. It is very important to talk to the county about, getting a permit for whatever you're, allowed to do. And frankly, from what I've heard, it's much worse in some Oregon places, but maybe you're from Eastern Oregon. I don't know. In any event, this is one of those, it's very similar to the last case in terms of what the violation is. And I want to hear from the public. Is there, Mr. Novich, at this point, do you want to be heard? You said you might.
Yeah.
Okay. Sir, someone from the public wants to speak.
Oh, I'm sorry.
Yeah, if I'm understanding it correctly, and it is basically in regards to taking down trees, again, I would reiterate, what is the proof of what species have been taken down? We need to start acting in accordance with the mission statement, which for Citrus County, I'm sure many don't know, but it explicitly references native assets. So if he's removing native trees, that's probably bad. But if they can't prove that, who knows? Maybe that should be something that they can learn and begin to document and change and, I don't know, button up their cases, because I'll get mine dismissed again today, just like how I got my last one dismissed. But that's all I'll say.
I wouldn't prejudge anything. All right.
That's where we're going.
I mean, I'll say I can see it from the photographic evidence that these are not invasive trees. The logs are on the property in the photos.
There's some smaller logs. I saved the smaller logs for fence posts. I thought they would make good fence posts.
Page 2 of 6 on Exhibit A. If those are small, I mean, I don't know. Well, or in any event.
Anyway.
It's okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with the administrative costs to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the severity and irreversible and irreparable damage caused by the violation.
I think, sir, that based on the fact that you cooperated so quickly with the county, that's worth something as what we call a mitigating damage. So I'll assess a $1,000 fine, and then now you can go your separate directions.
We can do that.
All right, thank you.
Do that.
Thank you, sir.
Thank you. Where do I go to pay the $1,000?
I'll issue a written order, and then honestly, you'll have to talk to the county about how to do that.
Okay.
Thank you, sir.
Next two cases, Margaret P. Barrett, case number 2025-802, and case number 2025-803. Code Officer Alan Jonason, pages 6 and 7 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Please state your name.
Margaret Barrett.
Thank you.
Good morning, Miss Barrett.
Morning.
I saw you laugh at the Tom Riddle joke. Do you read Harry Potter?
Pardon?
Do you read Harry Potter?
Oh, yes.
Okay, I thought so. I thought you got that one. All right, go ahead.
Yes, sir. Alan Jonason, Citrus County Code Compliance Officer. This is a repeat violation initially observed on 28 May 2025. The address of the violation is 10236 East Pike Drive, Inverness, Florida. This is case number 202500802, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This property is roughly 0.42 acres and is zoned CLR-MH and was purchased on 1 May 1993. Property owner is Barrett Margaret P., has previously been found guilty of the same violation at the same location on 24 April 2023. That was case number 2181784 with $0 in imposed fines. That case was abated on 23 May 2023. I have good service via posting the notices on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, findings of facts and order acknowledging compliance from previous case number 2181784. Exhibit B, photos I took during my initial inspection on 28 May 2025, and photos I took during my subsequent inspections on 30 June 2025, 21 and 28 August 2025, 3 and 10 September 2025, and photos from my final inspection on 15 September 2025. Exhibit C, a copy of the notice of violation and hearing sent to Barrett Margaret P., a copy of the posting affidavit, a photo of the repeat notice of violation posted on the property, and a copy of the pre-hearing order.
Can you tell me a little bit about this case?
Yes, sir. So there was a lot of junk on the property, and initially I didn't realize this was a repeat violation, so a regular notice of violation and notice of hearing were issued. Then I realized after that it was a repeat. I posted the repeat on the same.
How do you determine that? Like, do you all put the name in or the address in first? Do you have a database? I'm just curious.
So we have a very astute legal secretary by the
You
name
do?
of Lori.
Well, that's true. That's
who,
true.
Who caught it, and then I immediately took
Okay.
action and posted the
All right.
property with the repeat notice, and that was on 14 August.
Okay.
But yeah, there's junk and debris throughout the property, and I've had great discussion since we've been here with Ms. Barrett about the case as well. So
Understood. So are you presenting both cases or just this one?
I'm going to do this one first,
Okay.
just because it's a repeat, and then I can jump.
I
right into
totally
the
get
other
it.
one.
Ms. Barrett, I would ask you to take your time looking through these documents and let me know if you have any objection to them.
Is there any way to reduce that fine?
Well, so ma'am, that'll be something that you handle with me, but I just need to know if you have objection to these documents. So you've also got a copy of the prior case order. I don't know if I issued it or the other
Put down again.
guy did, but
I'll probably do that. Yeah, they're fine.
I think it was me. Okay. Then I would like to take a look at those. Very good. Without objection, what's been proposed as exhibits A, B, and C are evidence. I do remember this case. Mhm. Ms. Baird, do you still have anyone living with you?
Yes, my daughter does all of this.
Yeah.
I've been in North Carolina. But I can show you a picture that yesterday it was cleared up as far as that carport and everything.
Okay.
Right, Mr. Johnson?
I have seen the
Would-
photos, and I explained to her about if she wanted to admit that into evidence, that she would have to relinquish her phone, and she doesn't want to do that, so.
Well, your testimony is evidence as well.
I mean, I can show you the picture.
I also explained to Ms. Barrett about the tent structure that's on the right side of the property, that most of those items have been moved into, that they cannot be there, and she understands that.
I see. It's an upgrade, it's just an illegal upgrade.
Yes.
All right, let me just take a moment to look through these. It's well documented.
Again, we have to take photos once a week just to verify
Yeah.
progress.
And there has been progress here.
It's all gone. Except the pod. The pod's still there. That's the next case.
I'm concerned, based on the photos, Ms. Barrett, that it may not all be gone. I understand what you're
No, I
saying.
mean, under the carport.
Exactly. That's
what I'm
That's what I'm thinking about. And also the tent, I mean, everything under that tent structure is gone? you know
No,
what I'm saying?
see, he just advised me of that this morning. I didn't know that can't be there.
Well, look,
So I can get rid of that.
Here's the way it works. I mean, if you've got the stuff that qualifies as junk under the code, it's got to be either in an enclosed litter receptacle. It's got to be inside a house, like completely enclosed. It can't be outside and just covered from the rain. It's not good enough. So, anyway, so I've now seen the exhibits. Now, Mr. Jonathan, do you have any reason to disbelieve what Ms. Barrett testified to me about the living situation? And do you know?
So I have had brief contact, I guess, with her daughter. It was spirited, but there has been progress. And again, she showed me photos, and it does look like everything that was under the carport has been removed. My concern, again, is the structure that's off to the right, and those items and that structure coming down.
Ms. Barrett, the problem with this, of course, is that when your daughter creates this mess, you're ending up liable,
I know.
right?
That's why she'll get evicted, she does it again.
Oh,
She's been warned.
Okay,
Because
all
I'm
right.
tired of this.
Well, do you have anything else to say about it? I mean, I think the evidence is pretty clear, but I'd love to hear anything you have to say.
Well, I do have two questions. Her truck, which is that little black one, broke down again. And it's now sitting in our front yard. We can't even move it. The axle broke. And the engine, it's a weird thing. It's got two timing chains and they've got to be synced. So that's going to be that we got to pull the engine out because one's in the back, one's in the front. So that's going to sit there for a little while. So I'd like a time extension to get that.
Is that a part of this case, Mr. Jonathan?
It is not.
Oh, it isn't?
Well, so I wouldn't
Okay.
testify too much about it on the record here, if I were you.
I thought it was.
It's not going to be something I consider for this
Okay.
case. Is there anything else you'd like to tell
Well,
me?
on that tent type thing, what our initial use for that was is we do woodworking and.
Is that a yawn?
Possibly.
Wow. I thought.
I'm trying to be
I-
good today and not have a lot of sugar, so.
I'll have to be a little more entertaining, I guess. So I apologize, Ms. Barrett. For all right.
And epoxy, we do epoxy paintings and acrylic paintings, and because it was outdoors and we can get ventilation. So, and then it would give me a shelter from the sun. And that's what its initial use was for, but that's not going to work if I'm interpreting everything right.
You're talking about the tent?
Yeah,
Well, the tent, I'm not saying the tent itself is,
it's just what's stored in there right now.
that's correct. That's what I'm saying.
Okay, okay.
Is there anyone from the public who wants to be heard on this case? All right, I don't see anyone. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs to begin on the date of the posting of the repeat violation notice, which was 14 August 2025, and continue until 15 September 2025, which is when I did my last inspection. That would be 33 days at $100 per day, totaling $3,300. And a fine of $200 per day from this day forward until the violation is abated. We would also ask the special master additionally find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Just want to make sure I heard right. So I thought you said, I could be wrong, 14 August 2025 to 15 September?
Yes, sir.
Well, today is the 17th. So I think you're asking till the 16th, or?
No, just till the day that I took the photos on the 15th.
Really? Okay.
Yes, sir.
But then you want me to assess a higher fine from yesterday onward?
From today forward.
Okay, that's why I'm saying.
She's getting a free day.
Just because I wasn't there
Okay.
yesterday and I couldn't.
Okay,
I
got it.
can't hold her
No,
accountable for that because I.
Okay, I'm with you. I understand. So, well, first of all, that's the lowest repeat violation fine I've ever heard from Citrus County. I also think that you could have started it months beforehand. So, anyways, this is a deal from the county's perspective. I'm going to find that the property is in violation. I'll assess a $100 a day fine from August 14th to September 15th, and from $200 from today's date forward. It's very important to go out there, fix what's remaining, call the county to try and get out and stop the bleeding, okay? I think that's it.
Yes, sir.
Okay. On that case.
Yeah.
Yes, ma'am. Ready for the second?
I'm ready.
Okay. This is case number 2025-00803, Land Development Code Section 3140, temporary uses, Table 3-2, portable storage units, or a pod on site. The address of the violation is 10236 East Pike Drive, Inverness, Florida. Property owner is Margaret P. Barrett. This property is roughly 4.2 acres and is zoned CLRMH and was purchased on 1 May 1993. I have good service via posting on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 28 May 2025, photos from subsequent inspections on 30 June 2025, 3 September 2025, and photos from my final inspection conducted on 15 September 2025. Again, I made an error on this one. I cited the wrong LDC on the first initial notices. That month was not a good month for me for whatever reason. So Exhibit B is a copy of the original incorrect notice of violation, a copy of the corrected notice of violation, a copy of the incorrect notice of hearing for the August hearing, a copy of the continuation letter, a copy of the notice of hearing continuation letter posted on the property, a copy of the posting affidavit, and a copy of the pre-hearing order.
I, for one, for whatever it's worth, always appreciate the honesty. I expect it from witnesses here. You know, there was an episode of Star Trek called Space Seed, and it was where we were introduced to Khan Noonien Singh. And Lieutenant Marla MacGyvers was very busy admiring Khan and got distracted. And she made a mistake, and she admitted to it to Captain Kirk. And Captain Kirk said, you know, it's a lot easier to overlook something when you're honest about it. So that always obviously brainwashed me. So let me just take a moment. I'm going to admit Exhibits A and B as evidence. I've already seen this to some degree from the other photos. So please proceed.
On 28 May, I conducted my initial inspection and observed the property to be in violation. On 28 May 2025, a notice of violation was issued for LDC Code Section 3102E, Special Requirements for Accessory Uses. That was the incorrect one. On 30 June 2025, I conducted a compliance inspection, observed that the property was in violation, and a notice of hearing was sent via certified mail. On 13 August, I discovered that I had cited the incorrect LDC again from a very astute legal secretary, Lori. And on 13 August, a correct notice of violation of notice of hearing were sent to the property owner via certified mail, and I posted that same exact day on the property on 3 September 2025. I have had brief contact with the property owner, and as of my final inspection on 15 September, the property remains in violation.
Okay. So, ma'am, do you understand what this case is about? All right. And how much time do you need to get rid of it? Or, well, actually, so what I have, temporary occupancy of a recreation vehicle is permitted 2 weeks.
That's the wrong.
Okay, I mean, that's just what's in the agenda. No, I understand. So that's what's in the agenda, and then so I assume you have the corrected.
Yes, sir.
So let me just look at the packet. Right. Okay. Are you going to remove it from the property?
We are right now. I'm storing all the drywall and some furniture because we're doing the renovations inside the house. So I'd like some time to finish that and be able to move that because the drywall I can't get wet and it's kind of the wet season.
I'll be honest with you. I'm normally receptive to that kind of thing, but I am not when it has the effect of letting you violate the code for your purpose and then just getting rid of it and then there's no cost. In other words, if I give you enough time to use the pod there, then it becomes a precedent that, man, all I need is to illegally put this pods container on there with no permission, and then the special master will just give me whatever time I need. It means that the law doesn't exist. So I have to act like the law at least exists. So let me tell you what I'm thinking. I'm thinking 10 days. Yeah. It has already been there for 4 months at least. So how much time do you actually need, by the way?
I was kind of hoping for 30, but I'll take less, you know. I mean, I don't know where I'm going to, she's just going to have to put it in the house.
Or you're gonna have to buy a storage unit somewhere, put
Yeah,
stuff in
but-
there.
That's more money, so.
Get a permit. I don't know what it takes to get a permit for these. Are they ever allowed to have a permit for something like this?
I'll defer to Joanna Coutu.
I don't think so.
No, you can't have a permit for a pod type structure for storage on residential.
Even when they have like a permit for interior renovations or something like
There are
that?
no interior reservation permits in-house right now. I don't know what she's doing. Now, if it's like painting or something, you don't need a permit for that kind of stuff. But if you have an active permit, then yeah, you can have something there storing your equipment.
Well, so that's one way. I mean, if you are doing something that you would need a permit for, maybe you could apply for a permit, and maybe that would ratify it being there. But barring that, I'm gonna give you 10 days. Okay? Now,
I'll accept it.
what is,
$100 per day.
okay, is there anyone from the public who wants to be heard on this case? All right, then 10 days, $100 a day, if not brought into compliance, good luck.
Okay.
Right?
Thank you.
Thank you.
Thank you.
Next 4 cases, we're gonna do them together, but we'll state each address within that case for
Okay.
the record. Next case is Boa Vista Properties LLC, case numbers 2025-1033, 2025-1034, 2025-1035, and 2025-1037. Code Officer Julie Wilkinson. Pages 9, 10, 11, and 12 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your name.
Daniel Diaz?
Thank you.
Okay. Mr. Diaz, are you a representative, owner, or agent of Boa Vista Properties LLC?
Yes, I'm on.
Okay. Are these site clearing cases?
Yes.
All 4 of them?
Yes, sir.
Are you contesting that there was site clearing?
I'm not contesting, honestly. Unfortunately, I just didn't know. First time building in Citrus County. And in Marion County, you can clear.
We hear a lot of that in these hearings.
Unfortunately.
that it's
That's what I'm hearing now.
Which is really, I'll tell you, Marion County is not some heavenly regulatory place, so it's always interesting for me to hear that. In any event, let's go through it. I mean, unless you're, well, tell me this. So what, let's assume that the evidence shows it's pretty obvious that the
It
lots.
is. I'm not contesting.
Yeah, right. What would you want me to know in your favor?
Just that we are planning on building on the properties. We do have 2 permits that we've attempted to get on 2 properties. We're just waiting for them to be approved.
These are like single-family
Single-family
residences?
residences. And the other 2, basically, we're waiting on to figure, because we're not familiar with Citrus County, figure out on those 2 how things work to start on the other 2,
Yep.
basically.
And you say you already build in Marion County?
Correct.
What part of Marion County?
Marion Oaks.
Marion Oaks.
Yes.
Okay, and have you been talking to code enforcement about these cases?
To be honest, we just called them on Friday because we didn't get the notices.
Yep.
We just found the basic paper on the lot.
Okay.
Because
All right.
certified letters got sent back because nobody was there. And we thought that way.
Well, what is the, I mean, I have a feeling I know what the county's gonna recommend, but what is the county's recommendation?
$5,000
On
for
each?
lot. Yes.
So historically, what I've done, and I understand that Citrus County has a plan, if it's any consolation, that, you know, they take these fines and use them, I think, for the beautification of the county. Is that right, or am I wrong?
Correct.
Okay. Well, I'm not gonna do 5,000 per lot. I am suitably persuaded that it was a good faith error because I have heard this about Marion County as well. Now, it doesn't mean that, I mean, it's hard to gauge, like, what is a more culpable site clearing than another. It's very rare that you hear one where it's like unrepentant, in other words, although I think property rights is a good excuse, you know, ideologically. But in any event, what size homes are you planning on building on these, and how big are the lots?
1,300 square foot homes.
They're how much?
1,300 and change. 1,344.
Okay, gotcha. Bless you.
Thank you.
2 or 3 bedroom?
3-2.
3-2. It is in the county's interest to, bless you, support affordable housing being built as well. here's what I'm gonna do. I'm gonna go case by case. So on case number 25-1033, which I think is the first one on the list, I'll do a fine of $2,000. On the next case, 25-1034, I'll do a fine of $1,500. On case number 25-1037, there'll be a fine of $1,000. On case number 25-1035, a fine of $1,000. They requested $5,000 on each case.
I understand, something has to be done, I understand.
That's the issue.
Ignorance is not-
There are a lot of new builders in Citrus County, right? And you'd be amazed how many of these we have, so.
I'm starting to see that.
Good luck.
Thank you.
All right.
Thank you.
I hope not to see any of that.
I hear you.
Next case, Melissa R. Craddock, case number 2025-1080, Code Officer Alan Jonason, page 16 of your agenda. Expert on the case, Land Development Director Joanna Katu.
She's already been sworn.
Yes, that's correct.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-01080, Special Requirements for All Accessory Structures, a violation of Citrus County LDC Code 3102. Address is 4760 East Ginkgo Lane, Hernando, Florida. Property owner is Craddock Miss Melissa R. This property is roughly .22 acres and is zoned CLR MH and was purchased on 8 September 2021. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 8 July 2025, photos from a compliance inspection on 7 August 2025, and photos from my final inspection conducted on 16 September 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing notice.
Tell me about the case.
So there is an RV on the property. There was some kayaks and other things. When I went yesterday, it appeared that most of those items have been removed, and the RV may have been in the process of being removed. But as of yesterday, the RV was still there.
Okay. Have you had contact with Ms.
I have
Craddock?
not.
Okay. So, Ms. Craddock, I'd like to, first of all, is everything off the property at this point? Okay. Are you contesting whether a violation exists on the property?
Kind of.
Okay.
So I know everything needs to be moved off. I bought a house or a property 3 lots over, and we were storing things on this property. We also cut down trees and everything. That's why I know about the other case, about the cutting down trees, and stored the logs and pieces and everything over there on the ginkgo lot in order to be able to burn it. In the middle of the summer, that's when it was happening. There was burn ban on, so we couldn't really burn the stuff, but he's talking about the stuff that's on the property, the RV. Anyway, so we got our certificate of occupancy on August 1st for our new house, and we're in the process of moving everything over to our new house.
Okay. Well,
So it's,
I mean, it sounds like you are conceding that there's storage on the property, a
There is
vacant
storage,
lot,
yes.
vacant lot that doesn't have a permit for the construction of a home on that lot.
so what I'm contesting is the definition of a vacant lot, something that has never been developed. Is that the correct definition? Or
No.
just something that's, okay, because it's previously been developed and it previously had a home on it. I bought it after the home and everything was taken down.
No, it's just a lot that doesn't have the principal use established. So right now, there's no principal use on there. That's why. So
Okay.
I get what you're,
Then that's what I was contesting, is if it was previously developed, then it wouldn't be considered a
yeah, it
vacant lot.
doesn't like create a permanent exemption where then, you have to have the principal use on the property.
Okay,
Okay.
all right.
Well, in that case,
then-
how much time do you need to get everything off the property?
If we could have at least 30 more days, because we're trying to get a shed over at the new house so that we can put like lawnmowers and all the rest of the stuff in there.
Well, then I need to see the photos. Ms. Craddock, can you take a look at these documents and let me know if you have any objection to them being evidence?
RV, the kayaks are gone, the jet ski's gone. We do have fires over there, so we have chairs out so that we can sit and watch the fire, so it's not,
Ma'am, I just need to know if you have objection to the documents, and then I'll take a look at them and try to figure out how much time is.
Yeah, and most of it's gone.
All right, don't hear any objection to them, but let me just, okay. Yeah, I can already see that there's really not much left.
No, it's just the camper and just a couple of things that we need to clear up around it.
Well, why would you need 30, I mean, I'm just curious, I mean, why would you need 30 days for this? You could do this in an hour.
I work nights and,
I mean-
got off work this morning. Yeah,
Like less than an hour.
yes, a lot of the stuff needs to go to the junkyard.
Okay.
The camper needs to be moved with a certain ball and vehicle.
Okay.
So I need to get that arranged to be able to have that moved to my new property.
Okay. All right, well, let me take a look at the other documents in here. Original citation, July 8th. All right, is there anyone from the public who wants to be heard on this case? All right, I'm gonna find that the property's in violation, give you 15 days to, bring the property into compliance, and if it's not brought in compliance as ordered, what's the county's recommendation?
$150.
We'll do a $150 a day fine, 15 days. Good luck.
Thank you.
Thank you.
Next case, Randy W. Guy, case number 2025-1199, Code Officer Cody McGuire, page 21 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, and nothing but?
Yes, I do.
Please state your name.
Deborah Guy.
Now, ma'am, do you reside on the property?
Yes, sir.
Okay,
Randy's not here because Randy passed away.
all right. When did he pass away?
October 4th, 2023.
Are you an heir or?
I was his widow.
Widow. Did you ever probate the property or?
We're in the process, loss of income and then stress, but when he passed away in October, I also had 2 subsequent deaths within 8 months of his
Oh, I'm not
passing.
complaining. I
So
mean,
I'm just like,
yeah, no, I just want to understand
Dealing
your
with a lot.
relationship to the property, but it sounds like it was your homestead at the
Yeah.
time that he died.
yes.
Okay. Please proceed.
Okay. Cody McGuire, Citrus County Code Compliance Officer, case number 2025-01199, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 7898 West Riverbend Road, Denellen, Florida. Property owner is Randy W. Guy. Good service via signed certified mail return receipt and posting at the Canto Government Building. I'd like to authenticate the following documents and request to be admitted into evidence. Exhibit A is photos taken during initial inspection on July 21st, 2025. Photos taken during a corrective action inspection on August 4th, 2025. And my final photos on September 15th of 2025. And Exhibit B is a copy notice of violation, notice of hearing, copy of the general pre-hearing order, and the signed certified mail return receipt.
Ma'am, are you contesting whether there's a violation on the property?
Yeah.
Okay, all right. Then I'd like to give you an opportunity to look through these documents and let me know if you have any objection to them.
I was able to download the first pictures from the first thing, and I spoke with Mr. McGuire about those.
Okay.
What everything was doing.
Okay.
Looking for the last one. Okay, my trash can. That tire?
This is a different layout than.
Okay,
what's-
that just came.
Why
I
is it
think they're
different?
different
That we were
desks,
using to
too.
transport, the tire split.
Yeah, they changed it for a PEC meeting.
I see.
Yeah, we couldn't pick up all the nights for some reason, so they had to
Okay, gotcha.
And with this trailer here, what's this?
It's just the items that are stored in it.
Oh, it's fishing equipment.
Well, ma'am,
That's
I
for-
just
that's for
want
wade
you
fishing.
to let me know, we'll be able to comment and talk about them, but I just want to know if you have objections to them being evidence. Like,
No,
are
not at
they, okay,
Because I can explain it all.
all right. So without objection, what's been proposed as Exhibits A and B will be evidence, and I'm going to just take a moment to look. it appears that there was a lot of improvement by the time of the hearing. Is that accurate?
100%.
Okay, please proceed.
So on July 21st, I conducted initial inspection, observed the property to be in violation, it had discarded automotive parts, metal cages, construction materials, and other items. On August 4th, I conducted a corrective action inspection and discovered that the property remained in violation, but a significant change. And then as of my final inspection on the 15th, there's just a few items that remain.
What remains as of the 15th?
The discarded tires that are leaned up against the fence to the right side of the trailer.
What else?
And then I just learned that the items that were in the trailer were fishing supplies, so those are good.
It's just the tires?
Minimal.
So on the Becker scale, we're talking about a 0.1?
Yes, sir.
So, ma'am, in looking in the original photos on this case, I thought it was absolutely clear that this was a junk case. In other words, there were cans strewn across the property. There's a lot of, bless you, there were a lot of things undercover that really shouldn't have been there. As I look at it as of the last photos, it appears to me that it's really pretty much cleaned up.
Okay, and to go back to the very first pictures, the covers and everything, my husband was a scrapper.
Mm-hmm.
Okay, that's
Right.
what he did. That was his retirement dream.
Right, right.
When he got sick and could no longer do it, it just accumulated. When he passed, I didn't have anybody to take care of it.
Yeah.
My yard looked like an overgrown jungle. But
Right.
thankfully, my cousins needed a place to be. So I invited him up here and I said, hey, we can fix this for you. He
Mhm.
knows scrap. I said, please. So the awning, the tent you see, wasn't covering scrap. It
Mhm.
was giving him a shady workspace to break down all the scrap. And I have all the
That
receipts.
doesn't, that's not.
But that's what
I
got
understand the
neighbors
reason,
to call for
right.
violation.
It is a
wasn't that it
violation.
was an accumulation. It was the breakdown of the accumulation.
Well, it was
'Cause
both.
everything was in the garage, and he's pulling it out and separating it.
Well, you should do it in the garage. You know, in other words,
You couldn't work in there.
Well, but what I'm trying to tell you is, you are right, but also wrong in that it was an accumulation. It stayed there over a long period of time, and that's what you can't do. So if you create the shaded space,
The thing is, nothing had. Okay, when he died in 2023, I mean, my world stopped, literally.
right?
So getting somebody to actually start working on this stuff
Yeah.
is what caused the violation. Was him working on getting rid of the stuff.
Yes.
Wasn't the stuff, the people that called the violation in had only been moved in for 2 years.
Well, I'm
behind
just
me.
trying to get you to understand.
And I'm like, okay, so instead of coming and asking me, hey, everything okay, I noticed this is going on in your yard. Anything we can help with? No, they just call code enforcement. I know, this day and age, I understand people are leery, knock on doors.
All right, but the property does look largely cleaned up. You agree
Yeah,
with that?
and the tire that he mentioned, it blew on the trailer we were using to haul scrap. So that still has to go back to my dad's house so he can get the tire fixed.
Okay. Do you understand what needs to be done to bring the property into
Yeah,
compliance?
get rid of the tire and
Okay.
keep my trash cleaned up.
What's the county's recommendation?
$100 per day.
Is there anyone from the public who wants to be heard on this? All right, I will find that the property is in violation. I will grant you 7 days to somehow
Get rid of that
find a
tire.
way to clean that up. And if it's not brought in compliance in 7 days, $100 a day, okay?
All right, thank you.
Thank you, ma'am.
Thank you.
Next case, in Mobilari Mazal LLC, case number 2025-1072, Code Officer Alan Jonason, page 22 of your agenda. Nah, that's okay.
I didn't say the name. Oh.
That one
wow.
doesn't count.
Yeah.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-01072. Excessive growth and accumulation of vegetation, of violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. Address is 2970 North Chandler Drive, Hernando, Florida. Property owner is Immobiliaria Mazal LLC. This property is .22 acres and is zoned PDR and was purchased on 17 December 2022. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection.
Is there anyone here from Immobiliaria Mazal, or?
No, but someone from the public.
Okay, gotcha. Okay, that's what I wanted to know.
Photos taken during my initial inspection on 1 July 2025. Photos from my compliance inspection on 31 July 2025. Overhead photos from the property appraiser's website from 8 October 2022 and 23 July 2023 showing this vacant property has been previously maintained. And photos from my final inspection conducted on 16 September 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, a copy of the pre-hearing order, and a copy of the sunbiz.
All right. Without objection, what's been proposed as Exhibits A and B will be evidence. Were you expecting anyone? I'm just curious. Okay. Why did you tell me about the aerial and that it was previously maintained? Due to the exemption in the code section?
Because it's a vacant property, and vacant properties, for the most part, unless they're developed, do not have to be maintained.
Right, under the exemption?
Yes, sir.
Okay, got it. Just want to make sure. Let me take a look at these.
And you can see from the aerial that that large tree fell down sometime between May of 2024 and June of 2025.
Yeah, I agree that that is clear, and that it was maintained. Okay, please proceed.
On 1 July 2025, I conducted my initial inspection and observed the property to be in violation. On 1 July 2025, a notice of violation was issued for excessive growth and accumulation of vegetation, which is a violation of the ordinance mentioned earlier. On 31 July 2025, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 16 September 2025, the property remains in violation.
All right, is there anyone from the public who wants to be heard on this case? Sir and sir, okay. He's gesturing, if you would like to go first, Mr. Novich, you can. Okay.
So 20-61 is in direct conflict with FS 373.185, the Florida Friendly Landscaping Ordinance. So I would just ask that you look into that.
Thank you.
And that's all.
Do you swear to tell, are you both going to speak? Do you swear to tell the truth, the whole truth, and nothing but the truth so help you?
I do.
Please state your names.
My name is Ernesto Rubio.
That's what I thought.
I'm Catherine Carter.
Okay, thank you. Let's do one at a time, so whoever would like to go first.
So I'll go first. I'm a nearby neighbor. That tree came down from the hurricane last year. This house is within a homeowners association. The owners have been noticed by the homeowners association to take care of that tree. That's why the property was maintained. We have a covenant that says if your lot had been cleared, you must continue to maintain the lot. We do have lots in the area which are not maintained because they were naturally that way. So I just wanted you to know that this owner has had plenty of opportunity to take care of this, and now we're in front of you.
Have you had contact yourself with the owner?
We have not. I have not.
Okay, all right. Ma'am?
Hi, I am Catherine Carter. I am the treasurer of the Canterbury Lake Estates Property Owners Association. Our art committee did many reach outs. We've served both the property address that is listed with the property appraisers, as well as what is under the Immobiliaria Mazal LLC by certified as well as regular mail. The previous management of the Immobiliaria changed in March of 2025 according to Sunbiz. And since that time, pretty much any correspondence has been ignored. They have refused to pick up any of the certifications. However, there was, as we serve regular mail also, apparently something triggered because the property went up for sale about 60 days ago. The property owner, we have been told, is actually physically located in Peru. So their property taxes remain unpaid, our dues remain unpaid, and now we have a situation where it's an eyesore as well as a health hazard at this point.
Is there anything else you'd like me to know?
I think that's it. If you have any questions, be happy to answer.
I appreciate that. I don't. Thank you. All right, what's the county's recommendation?
$200 a day plus administrative costs.
I mean, the thing about a case like this is the remedy is really not very difficult and can usually be done quickly. It's a relatively old case on this, so I'll do 14 days to abate the violation, and if it's not brought into compliance as ordered, you said 200?
200, yes, sir.
I'll defer to the county on this, $200 a day.
Thank you.
Thank you for your time.
Thank you, folks.
Next case, Michael R. Novich, case number 2025-1388, Code Officer J.C. Charlton, page 25 of your agenda.
And Mr. Novich, just so you know, I don't know what the county's purpose was specifically because they haven't talked to me about it, but normally if there's an idea that there might be a longer hearing, I ask that it be held till the end, just so you know. So that's more my doing. I don't know if this is going to be long or not. Frankly, I have no idea.
I was almost wondering if I'm worth less than a ghost
No,
here.
no, you're not the only one. There's others who we know that it
Yeah.
might be longer. So I do that so we can get everyone else out,
Yeah.
just so you know. All right.
Good morning.
Good morning.
J.C. Charlton, Citrus County Code Compliance Division Director. This is case number CE 2025-1388, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 66 South Columbus Street, Beverly Hills, Florida. Property owner, Michael Novich. We have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on August 13th, 2025, corrective action inspection on August 27th, and follow-up inspection on September 4th, and my final inspection on September 16th, 2025. Exhibit B, copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a copy of the pre-hearing order.
Can you give me a narrative of the case?
Yes, this case is for overgrown lawn. Initial inspection conducted on August 13th. I observed vegetative matter piled up on the left of the property, and the backyard was overgrown and unkept as well. I received access to a neighboring property to see piles of vegetative matter and overgrowth and unkept in the backyard.
Have you had contact with Mr. Novich prior to the hearing?
Yes, I have. On August 25th, Mr. Novich called the office, inquiring about the violation. I explained the violation to Mr. Novich and that the violation for unkept and overgrown was in the back.
So it's not for something in the front, it's for just what's in the backyard?
All right, on the front of the property is the pile of vegetative matter to the left of the home.
Okay. So it's for two sets?
Correct.
And you explained it, the county's case on August 25th?
Yes, sir.
And did he, I don't know yet what he's going to say, but did he mention the Florida Friendly Landscaping Statute?
No, we
Okay.
did not talk about
I'm gonna
that.
look into that.
And
go ahead.
all right, when I explained to him that a corrective action inspection will be conducted on August 27th, and he stated that it would be ready for reinspection, so I went out on August 27th, and the inspection failed.
did any part of it pass from your perspective?
No, sir.
Okay, so in both areas, the county felt that it was still a violation of the county code?
Yes, sir.
Okay, then normally the way I want to start is ask you, Mr. Novich, just to see what they've got, and let me know if you have legal objections to the documents. And of course, you'll have an opportunity to cross-examine and present your own evidence. And what I'm also doing is trying to review the Florida-friendly landscaping statute.
So these actually prove my point, so we'll admit these.
Okay. Then without objection, what's been proposed as Exhibits A and B will be evidence.
I think that's, yes, that too.
And I don't see any other members of the public present, so I don't know if we need to ask for public input anymore. Let me just take a moment to look at these documents so I can understand where the county's coming from. All right, please proceed.
I went through my whole.
Okay, so that's what you were going to tell me.
Yes.
I will say before we get to Mr. Novich, he's already mentioned the Florida-friendly landscaping statute, and I want to just take a moment to talk about it. So I'm looking at Florida Statute 373.185. I don't agree with the assertion made earlier that it invalidates the ordinance. But at the very end of this statute, it does say, a local government ordinance may not prohibit or be enforced so as to prohibit any property owner from implementing Florida-friendly landscaping on his land. And then when we look at what that landscaping is, it says, quality landscapes that conserve water, protect the environment, are adaptable to local conditions, and are drought tolerant. The principles of such landscaping include planting the right plant in the right place, efficient watering, appropriate fertilization, mulching, attraction of wildlife, responsible management of yard pests, recycling yard waste, reduction of stormwater runoff, and waterfront protection. Additional components include practices such as landscape planning and design, soil analysis, the appropriate use of solid waste compost, minimizing the use of irrigation, and proper maintenance. The reason why I'm reading this is because it does occur to me that there's a tension between this statute and local ordinances, because take that attraction of wildlife part. Traditionally, when we consider code and nuisances, one of the overarching reasons why we have the code sections here and everywhere else in Florida is to prevent some wildlife from living in overgrown areas like pests, rats, things like that. Okay, so have you all considered these? I'm just curious if the county has considered these arguments before the hearing.
Yes.
Okay, all right. Mr. Novich, it's on you. What would you like to say? Or you can cross-examine, you can go ahead.
Oh, yeah,
I just
no.
want to make sure we do it the right way.
Well, just to kind of frame this a little bit, what's interesting is I actually have a legal objection that I'm just choosing not to utilize as far as the evidence. One, because it does prove my point, as I stated previous. But just because I'm sure now you may be curious, what could that legal objection be?
I am.
And that's going to be on the grounds of essentially the access and the spacing on where these photographs were taken. I'm under the impression that J.C. Charles and essentially coveted access to the neighbor's property. That conversation with 6-8 South Columbus Street actually begins with me calling due to a prohibited species in county-owned right-of-way. That species was bamboo. I call code to report this. I believe I actually get a voicemail back from Julie Wilkinson. I don't have the dates, but they can, do all that. I want to say that they actually call me back, leave a voicemail, and they basically say, hey, the bamboo, that's kind of on the line, but it was half over, half on. The radius of this clumping bamboo, just so that we understand, the bamboo is a very aggressive species. This is why, per our LDC, it is a prohibited species.
Timeline-wise, was this after your last case?
Correct.
Okay.
So the bamboo situation, I don't know, maybe a month to 2 months
All
ago. It kind of somewhat immediately preceding this dealio, by maybe a couple weeks.
Okay.
So there's a large diameter of bamboo. It's straddling the line. It's several feet into county-owned right-of-way. And as we established at the last, with my previous 7320A that was dismissed or found unfounded, whatever, county can do what it wants in county-owned right-of-way. So it's just curious to me that I call in for bamboo in county-owned right-of-way, and what do? They go and pass the buck. They knock on the door of the homeowner, because we don't like to do our jobs, apparently. So they then knock on the door of homeowner, who's actually a rental property. The person who basically bought it, or I don't know if he's just an agent of that LLC or whatever, he then takes it up, I guess, upon himself, probably at the pushing of county, to then clear the bamboo. Now, the property owner just comes out and just cuts all the bamboo down, and off we go. The problem is that the bamboo still exists.
Mr. Novich, so I just want to make sure, is this all related to an objection you've waived?
Correct.
Okay, well
because the photos prove my point based on species.
Okay.
So I guess to cap that up, we see Biden's alba in there, which is the small flower with the white petals and the yellow center. Per the Florida Plant Atlas, which is the top resource, this is the Florida Plant Atlas is that's basically a joint effort from USF and our water institutes and really top tier stuff. Biden's alba is a native plant of Florida. And so I'm under the impression that Biden's alba, along with every Florida-friendly species, which includes not just natives, but Florida-friendly species, is not going to be bound by 26.1. Citrus County does not supersede the state of Florida in any way. So we're going to be bound by what we're bound by, and I'm all for rules. That's why, I try my best to follow the rules. And sometimes I'm mistaken. And sometimes we have to have things kind of clarified. But to finish my point on how this was an objection, county had no right to reveal my information to the property owner of 6-2. What county did
Mr. Novich,
is they knocked on the
Mr.
door.
Mr. Novich, I do want to I normally don't interrupt because I want you to have an opportunity to lay your record, but you already waived the objection, so I'm really not interested in the stuff having to do with an objection you waived.
That's fine.
I'm just getting irrelevant.
I'm just getting it on the record because we can't be giving my information
But you
out.
waived the objection, so it's not relevant to the record. I get what you're saying, but that's for another. What I think we need to get to is the meat, which is it sounds like the county has two different, one in the, I guess I'll call it the front, even though it's the side, I guess, and then one in the back. How do you want to do this?
And to speak on that, we all heard JC begin just minutes ago where he actually, I'm pretty sure even on the record, he states that the violation was in the back. You then clarify, and then he adds the front. So when I call in,
He did say it originally. I was asking for clarification. He did mention both in the beginning, but he mentioned it on, like, I think the left side of it. So I'm clarifying, is that a part of the back? But I want to get to the
even
meat.
then we'd have to clarify additional because it's left side when facing the property, left side when,
Do you
so-
understand the two areas that he's talking about? Or are you not clear on it?
So I'm assuming that he's referring, which actually, let's just start some cross-examination. When you say the left side of the property in the front, are you referring to facing the property, JC?
Facing the property.
Okay, perfect.
Okay.
So that's the bamboo there.
Well, now you got to finish your cross-examination. So you have an opportunity to perform the cross-examination you want.
Okay.
And
So
then
did you reveal my identifying information to 6-2?
that is
No, I
not
did not.
relevant to the issues.
Even though the 6-2 is where the photos were taken.
You would waive the objection.
That's fine.
Yeah, so I
Okay.
mean, if you would wanted to make an issue of
Okay.
it, you don't waive it.
I got
Sir, I don't want to do this again. I will give you every opportunity to be heard and to make your case.
Yeah.
But I can't be interrupted every time I'm speaking.
Okay.
You're not in control of the hearing. I am, right? So here's what I want to, please do your cross-examination.
Yeah.
You have that chance.
Okay. When you're doing 26-1 or 20-61 cases, or really any cases involving, our flora, which is all of our kind of plant and that kind of thing, how do you know what it is that you're looking at?
Oh, we research it. We look for, first we go out and we see if it's the grass or the weeds are excessive, over 18 inches. If there's piles of vegetative matter, that can be in the front, back, or sides of the property. And then we come back and we have to do our research on the case. And then if the respondent calls us and say, hey, this is what the violation is, or this is what I was looking to do, and then we respond to that accordingly.
Mm-hmm. So in your research on my case, how many native species did you see?
On your property?
Yeah, in the photos that you are presenting as evidence, how many native species to Florida do you see in those photos?
I've seen grass and weeds and vegetative matter.
So if I could just get a number for the record, how many native species do you see in the photos that you submitted today?
I don't have a number.
Okay, so we'll take the non-answer as a 0 then.
No, I'll be the judge of how we take things. You have an opportunity to ask questions.
Okay.
I'm listening.
Okay. Do you have any experience or like formally or even hobby-wise as far as native flora to the state?
No, I do not.
None. Okay. Do you like native species?
Objection relevance.
Sustained.
Okay.
Whether he likes it or not is not relevant to whether
What
they're
is your
there.
favorite native plant species to the state of Florida?
Objection relevance.
Mr. Novich, again, it's not relevant to whether or not it exists on your property.
Okay. Did you use any tools or methods or any type of kind of augmenting ability to look for native species?
No, I didn't. There was a measuring stick used for the grass.
And you don't know if the grass was native, though?
No, I do not.
How do you know that it was grass?
Looking at the photos and the weeds and the vegetative matter there, the grass is in excess. It doesn't appear to be a plant.
It doesn't appear to be a plant?
No.
You're saying that grass isn't a plant?
It doesn't appear to be, it appears to be that it's over the 18 inches.
So
And that's
we
why
have,
the notice was issued along with the vegetative matter and the weeds on the property.
right. So I have mealy grass, which is one of Florida's many native grasses. If mealy grass is kept
Mr. Novich, you'll have an opportunity to testify about what the grass is, whether it's native, whether it's not. This is your opportunity to ask questions, just questions of the witness.
Okay. Thank you. 1 second. Did you notice any wildlife while you were at my property? Any dragonflies, butterflies, Florida native green anoles, southern toads?
I don't recall, no.
Did you look for these?
No, I did not.
Okay. Do you agree with the Florida statute, which essentially summed up just says that it's really in all of our best interests as Floridians to kind of protect the state and have native species and native flora
I'm going
and
to,
fauna?
without waiting for an objection, ask that you rephrase the question, because whether or not he agrees with anything the legislature has passed is really not at issue.
Okay.
And it'll be for me to determine whether there's a violation, like find the facts or not. So,
Okay.
just his personal preferences are not on trial here.
Mm-hmm. Yeah, yeah. So 26.1, without having it directly in front of me, can you read 26.1, somebody, just for the record?
This is your opportunity to cross-examine, Mr.
Okay,
Novich. I'm
that's
not
fair.
trying to be difficult.
So
It's
then,
just-
can you define overgrowth, or even, can you define overgrowth for the record? I believe overgrowth is listed in 20-61, because it's grass over 18 inches, underbrush, overgrowth, et cetera. We're gonna need defining terms on everything.
Well, everything, there are definitions in the code, and what I'm going to do is not listen to his definitions. I'm going to look at the definitions of the
Is
code.
it defined in code? Okay.
We'll look at it, but this is your opportunity to cross-examine, sir. In other words, this is your opportunity about what his investigation was, the actual facts of the matter. It's not legal argument at this point. Are you done with your cross-examination?
1 second. I'm just re-reviewing. Where did you place this?
Let the record reflect that Mr. Novich is referring, I believe, to the allegedly posted notice on the property.
That was placed in front of your home in the rights-of-way.
And the reasoning for that?
To serve notice, because I hadn't had good service from you, showing that you were aware of the notice of hearing scheduled for today.
So you placed this in county-owned right-of-way, even though it was intended for me?
Objection asked and answered.
I think that's accurate. I think it is asked and answered. I mean, I think from our previous case, we've established that's county right-of-way.
So
I mean, your point is, look, the point of this hearing is to get in evidence so I can make a decision. I already know where it was posted. I already know where your property is.
Well, so 20-61, we just can't pick and choose. And what's happened here is months ago, Citrus County took things
Mr.
personally.
Novich, I want to hear, you have a right to make this argument. I just want to stick.
Yeah,
We're going to
yeah.
finish cross-examination before we get to any presentation or argument on your
Yeah.
part.
I don't live in the county-owned right-of-way, so I don't know why this directed to me was placed
Well,
out in what isn't
the
mine.
code does allow them, and I'm not going to find in your favor. You're also here, so it's not relevant. Because I gave I don't know if you heard me earlier
Yeah.
explain this. It's not relevant because you're here. So the only reason why that would matter is if you didn't show up because you didn't have proper notice. All right, so you need to finish your cross-examination of Mr. Charlton.
Is the grass that's in the county-owned right-of-way that's 30-plus inches, is that part of this case today?
No, I didn't observe it to be over 18 inches during my inspection.
Must have walked right past it. That's
And
interesting.
that is,
So
I got to get control of this, Mr.
I
Novich.
think that, yeah, but
Those
I
kinds
don't
of
have any other
comments
questions.
are not
Yeah.
appropriate. I do think you have the ability to make legal argument about bias or unfair selective enforcement is what we call it. But attacks on witnesses, I can't allow.
Yeah.
Okay. Have you concluded your cross-examination?
I have.
Then we move on to the presentation on your part. Do you have any testimony you'd like to offer or any other evidence?
Well, if we all want to just turn and look at our mission statement here, I'll read it aloud. Here in Citrus County, our mission is to manage growth and foster prosperity by prioritizing the protection of environmental assets, the development and maintenance of infrastructure, and the health, safety, and well-being of Citrus County citizens. Now, lately my life feels very surreal, and, you know, I would like to be able to just kind of, it's not even so much go back, but I'd like to just move forward. All I would like to do is literally just have my actions match my words. I live here in Florida's Nature Coast. Silly me, I thought, let me come here. I'm from the Tampa Bay area. You know, I've been here about 4 years. You try to get in where you fit in, right? That's all I'm trying to do. I give away free plants and native plants to everybody. That's how I got on the front page of the paper. This upcoming October, in my Florida Food Forest group on Facebook that has over 3,000 people, we're having a fall plant swap at the local park. We're all going to be giving away native plants and different things to each other. It's shocking to me how much flack I'm getting for doing the right thing. Not even morally and legally and that kind of thing, but it transcends that. I go outside, Christian, I literally see the most amazing things every day. Giant swallowtail caterpillars right on my Florida native Hercules club trees. I'm watching ladybugs that have larval stages. They're moving through. It's not just butterflies that's transforming out here, guys. We got all kinds of beautiful things. I have 20 plus native species. I don't know if you want to hear Latin. I run a group on Facebook called Native Plants of Florida. There's over 15,000 people in there. So to talk to me about native plants is silly. You guys need to come for me on some other stuff.
When you say 20 species, are you talking about like flora and fauna, just flora?
Just flora, just plants. If you build it, they will come. That's what some of my neighbor. I'm surprised the Michael Novich Private Hater Squad isn't here today. But there's a vocal few, but the majority is absolutely on my side. So the lizards we see everywhere, these brown lizards, that's not what's supposed to be here. Google green anole. That's what's supposed to be here, and that's who I see almost daily. I see native southern toads, multiple my phone is just filled with different species. Every day is an amazing time from different birds, different species. I've got cardinals, I've got robins, we've got it all. And it seems like Citrus County here in the Nature Coast just absolutely hates it. They just hate native plants. They hate all of it. And there's a lot of eyes on this here special master. There's a lot of eyes watching this, and I've put money into my home. I got nice new, mini splits. We took down.
Mr. Novich, I want to talk to you about the Florida Friendly Landscape Statute. So you mentioned it, and I want to understand your perspective on how it applies for this case. I think I get it.
Mm-hmm.
I think what you're saying is that I'm fostering Florida-friendly flora. I'm serving the objectives of the statute, and therefore, pursuant to subsection C, I don't know if 3C, that this ordinance should not be used to prohibit you from the two things that you have that are cited. So I want to drill down into what those two things are so that we can establish whether or not the statute applies or not.
Yeah.
The first thing, let's talk about what's on the left side front facing.
Mm-hmm.
What is that?
If you're facing the home on the left side, I did have some pieces of bamboo which are no longer there presently, and I basically used those to just kind of create like a natural kind of trellising.
So I'm going to show page 1 of Exhibit A. Is it the brown stuff that's on the ground? Was that the bamboo?
Yeah, those are the bamboo pieces.
Mr. Charlton, was it? I may have to go back and forth so that I understand what you guys are talking about. Was that a part of the case at first?
Correct.
All right, with the bamboo.
Correct.
And so when you say left side front facing, I'm looking at the area that you're talking about on page 1, right?
Yes, sir.
What else is a part of the alleged violation besides the bamboo?
Now, there was other photos taken yesterday's inspection. There was other vegetative matter up front also. I can show you.
Yeah, I want to give you a chance to show me where so that I have an understanding, and then Mr. Novich is on the same page. Those are the back. I want to separate those.
This is vegetative matter in the back as well.
Okay.
That's the back of the home.
All right.
This is the front.
From the front left. That's the front left? All right. So this is the only photo I have of what it looked like yesterday, and it's a little further back on the property. All right, let me show Mr. Novich so he can see what we're talking about. All right, so I'm looking at page 16 of Exhibit A, Ms. Harrison, so you can see as well. All right, now, I have questions about this, so I just want us to be on the same page that this is what we're talking about. So as of yesterday, Mr. Charlton, this is what you observed in the left side, front-facing left side area.
Correct. Yeah.
And what is a part of the violation here?
Appears to be just piles of vegetative matter.
Okay. And so
And
then,
could I see that one?
yeah, go ahead. And if you can, point out what the brown. So it's the brown, not the green.
And
Well, that's all in the back. So
yes,
we'll get to. I'm going to do it one by one. All right. So Mr. Novich, Mr. Charlton's identified the offending material, vegetative matter, as the brownish vine-like stuff. Do you see that? Again, page 16, Exhibit A. Do you see this?
Mm-hmm.
When you are prepared to speak, make sure it's on the microphone so we preserve the record. But do you know what that is?
So those are bamboo pieces.
Are you prepared to clean those up?
They're no longer there.
Okay.
I'm regularly cutting.
When were they cleaned
moving,
up? When were they removed?
Well, so actually, let me clarify. So, I'm almost because I had people over and there was we needed movement, which was my room essentially, which is why I moved the bamboo that was closer out of near the rear of the vehicle. I'm pretty sure that those pieces there are also moved, and I'm pretty sure that that's bamboo, but I'm not 100% positive.
I actually agree with you based on what you've already testified to. It looks very similar to what we saw in the first photo.
Yeah.
So I have no reason to disbelieve, frankly, either you or Mr. Charlton. I think the testimony lines up, and it sounds like this is technically a violation. Okay. It's not a Florida-friendly landscaping. Bamboo is not a part
What's
of-
the definition of accumulation?
Well, that's a good question.
Because if I can see through it, I mean, I
Well, if that's going to be your defense, I'll tell you.
Because we're
I think that's for me, that based on the plain reading of the term, it's just something that's accumulated, so it's gathered there. And I don't need there's no net weight requirement. So look, it's not the end of the world. I mean, I think that.
But I'm gonna be in here forever.
Really?
Forever, yeah. This is not, and then
I don't think so.
Other people's cases, well, maybe not today, but I'm just
Definitely not.
in perpetuity.
Because this one's
yeah.
easy. I understand what your point is, but I don't think that'll be necessary, because I think what I'm going to do is set my interpretation of how this statute works going forward so that it won't be an issue. But I think based on your own testimony about the bamboo, I do think that this is a violation. It would take you 5 minutes to clean up. So
It's
I'm not worried about
potentially
it.
not even there. It could be a moot point. But for the future, we must have the definition of accumulation, which is
No.
why during cross-examination
Look, so it's
I
in the
asked-
dictionary, and I think that I will, for the purpose
Yeah.
of just having us be clear.
I mean, because if two sticks touching is an accumulation, everybody in citrus is going to get written for
Well, no, that's the thing.
20-61, and I'll make sure of it.
that's not true.
Because we're not picking on little Michael Novich. I'm done with this.
Well, you're right and you're wrong. So let's look at the definition.
Because you look at that, Christian, remember, bamboo grows
Yeah.
like this. It's going out
Oh
laterally.
yeah, no, you're exactly right.
I know I
Look,
am.
a mass, a masser. Well, it's always good. I mean, I, as a special master, know very little, so I have to be educated. According to what I'm seeing, it's a mass or quantity of something that has gradually gathered or been acquired. It doesn't have a limit on what the mass is. This is a violation. It'll just have to be corrected. So I'm going to set that part. I think we're done with that.
What you've done here is you're saying that something that can be solved in minutes was done gradually. Think about that.
I have. And
So
in
then
fact, I don't
any
think
two
you've
sticks-
grappled. I don't think you've grappled with what this code says. We had a case one time with this code section where people were growing saplings, and the question became, how can you prevent the growth of saplings? And then how can I ever get a tree on my yard? They have to start as a sapling. They have to start it. So it seems like there's a tension there. But guess what? The words in this code section mean what they say. So it's up to y'all to draft and amend in a way that might be more consistent. But that's not a Florida-friendly thing. I want to get to the Florida-friendly stuff. So I want to move.
I don't want to brush over that.
Don't worry about. Don't worry
It's
about
all equal, Christian. That's what I'm saying.
It's not. It's not.
But
Because,
it is.
Because this is easy. That's easy. This
And
one
yet
may
I
not
disagree
be.
on that.
That's fine,
Respectfully.
and that's why you have the right to appeal. But
Well, it's not. I won't appeal. I'll just
Guy,
build
listen,
people and wall me in
please.
here.
If you just let me finish,
Yeah.
it'll go smoother. I think this is really easy. But now there are photos that Mr. Charlton set aside, and I'm going to put them on the record, which is pages 11, 12, 13, 14, and 15 of Exhibit A. And I think you've represented, these are photos of the backyard that were taken yesterday.
Correct.
Okay. I really am interested in these photos, and so what I want to ask you, Mr. Novich, is, and I want to give you an opportunity to look at them too, but what code has testified is that these are also in violation of Code Section 20-61. Now, are you making a defense that the Florida-friendly landscaping statute protects the stuff that is in these photos?
Well, every stick is now illegal based on what you just said.
Nope. So,
well, that's why I'm still trying to get clarity on.
It's clear. It's clear.
Not
as far as I'm concerned, and that's why you have the right to appeal. We're moving on. You can address it or not. So my question is, on these pages 11, 12, 13, 14, and 15, is there something that is protected by the Florida-friendly landscape?
We've already addressed. Well, actually, I would have to re-evaluate all these photos. I mean, you want me to go up there?
You have. Let's do this. I also invite you to take them to the podium so that we can hear you on the microphone.
Oh, I don't even. Yep, we're already done.
Okay.
Yep.
Okay.
What was the question? What's the question?
Is anything in these photos protected by the Florida-friendly?
Absolutely.
Okay, and
Yep.
so I'm going to show you picture 11. So what here is Florida-friendly landscaping?
It's weird that it's on me.
No, I'm just
to
asking you.
Almost.
No, the burden's on the county, but I'm
Yeah.
asking you, what is it? I
Well,
mean,
they already established they don't know what they're talking about with native plants.
I heard the testimony.
Okay.
So
I guess this is I'm just doing free game to help y'all. Okay, so that. Those are Biden's
it
alpha
isn't.
in the rear.
No, see, the way it works in hearings is usually like a plaintiff has to establish a prima facie case, and they have the burden of proof with their evidence. But if there's a defense raised, and you have raised a defense, then you have the burden of the defense. It's not like a criminal case, because you're right. In a criminal case, there's absolutely no burden at all on the defendant. This is a civil, it's a quasi-judicial proceeding.
Facts of the case.
Yeah, so like you're raising a defense, and
I got you.
I'm curious. So on page 11, what is
There's Corky. You're looking at Calicarpa americana in their rear. We got Biden's alba. We got Corky stem, Passiflora suberosa. I'm seeing, gosh, Christian. I mean, I don't even know. There's all types of stuff out there.
And then is it any different on page 15, or is that essentially just the same behind the fence?
Could be some Mimosa strigolosa ground cover in there.
And are the
it's
species
tough
names
'cause-
are the species names you're giving all like Florida native plants?
Sunshine mimosa is the same Florida native plant that started it all months ago. That the government hates. This government here hates native plants. More y'all hate native plants, more native plants I'm planting. So we gonna learn more Biden's alba. I can see it from a distance. Look how beautiful they are, Chris. Man, I love them. Native plants.
Is that what? So what's on this page 14? It looks like a white flower type plant.
Look like a terrible photo. We got to get
It's
better
dark.
photos.
It's dark, but I see some white flower.
More Biden's alba. They're
That's
all over.
Biden's alpha.
Biden's alba.
Biden's alba.
ALBA.
Okay.
Yes, sir.
And then on page 13.
Look at the Biden's alba. Is that some cabbage palm in the rear with more beauty berry? I got corky stem, passion flower going right up that beauty berry. Wow.
Where's the beauty berry? Boy, the pollinators love that.
So the beauty berries.
Okay.
Kind of right on the left side over here.
Okay.
It's-
All right.
There's that Florida native cabbage palm. You know everybody loves those.
I don't, but I like to be educated.
Well, everybody except for government, because again, we all love. And you know what's funny? Guess what's FFL? Or one of the FFL species would be crepe myrtle. So you know what's funny? You know what's funny, Christian? I'm
don't
not
like
even a big
those.
Florida-friendly landscaping fan. I got my own problems with UF and Claire with them. I'm just using that today because that's my legal defense.
UF?
Yeah, University of Florida. Everybody gets the same Mike Novich. So.
Like IFAS or I mean?
Oh
what's-
yeah.
Okay. Okay.
Ornamental plant industries out here ruining the environment.
Okay. So, Mr. Charlton, he has made a prima facie defense under the Florida Friendly Landscaping Statute. In other words, he's identified species that he's represented to me are protected under the statute, and therefore the code would not be able to prevent him from landscaping his backyard with that. So I'm wondering what the county's case and response to that is.
At this time, the statute doesn't specifically protect specific species of plants. That it is not outlined in the statute. It does not say plants A through Z are specifically protected. It does give guidelines, and what it looks to is certain practices. So the right plant in the right place, efficient watering, appropriate fertilization, mulching, attraction of wildlife, responsible management of yard pets, recycling yard waste, reduction of stormwater runoff, waterfront protections, as well as landscape planning and design, soil analysis, the appropriate use of compost, minimization of irrigation, and proper maintenance. This is where we believe the county's statute does align with Florida-friendly landscape practices, which are outlined in this statute. As we are basically requesting and enforcing proper maintenance of the plants that he does have. So they also have to be planted in the right place for those species, but the main issue is maintaining it in a responsible way so that he doesn't have an overgrowth of the yard pests or an overgrowth of the plants themselves so that they are not properly maintained.
You know, it's just, I look at this statute, and it actually says we want to attract wildlife. I mean, it doesn't limit it. It doesn't specify.
It doesn't, but then in the next breath it says responsible maintenance of yard pests.
That is
and
correct.
and
Okay,
that
I
would
got
be
you.
into
I got you.
the rats or the rodents and things that we usually.
So that qualifies.
Correct.
It's, what about raccoons?
It would just.
Are those pests, or is that wildlife that's? I have to
Can
ask.
I say something?
Well, I'm just having
Well-
a conversation first.
For the record.
Yeah.
Raccoons haven't been brought up today, so I would object to that. But it would depend. If they have reached the point of overrunning, destroying property, things of that nature, it would cross the threshold to pests. If you have a raccoon that runs across the property, if they move through the property but don't cause any damage or act in a pest-like behavior, then they would not be classified as a pest.
You wanted to say something, Mr. Novich?
This county is crazy. Do you know that our own LDC lists snakes as, quote, vermin? Now, if you ask AI and even legal precedent, snakes are not considered vermin. And you know what they are, Christian? They are our environmental assets, the likes of which are referenced in our mission statement. The more Citrus County lives in a hypocritical manner, the more pain, disease, and poison is going to just fill each of us and this land and these waters. No amount of Save the Waters Week is going to fix what we're doing here. Snakes aren't vermin, okay? I know we're not talking about snakes, but I'm just saying. And while we're at it, while Kimberly Harrison referenced the FFL list, guess what's in Chapter 5 of our LDC, Christian? Ligustrum japonicum. Do you know why that's meaningful?
Why?
Ligustrum japonicum is predicted to be invasive throughout the entire state by UF. UF does. So what this is, FFL is through University of Florida and IFAS. They do predictive analytics, because there's a process. Somebody just doesn't go like this one day, a thumbs up, and then, a species be designated invasive. There's work. They're studying species for years and years and years and years. The University of Florida does predictive analytics, and it's already been known, ironically, for years that Ligustrum japonicum is going to be invasive, and yet that's one of the species that we recommend. Chapter 5 of our own LDC, if you go to recommended shrubs, you see Ligustrum japonicum in there. It's like telling someone to put, dirt in their car's fuel tank. It's so silly. It's dangerous. And you know what? I've emailed Eric Landon. I've emailed people over and over and over to try to get this updated. Because in my mind, this is a practical, easy fix. I'm not asking for nobody to build a bridge. I'm asking for our list to be updated and for these species to be removed. Citrus County really ought to listen to Michael Novich. Instead, it wants to take things personal and then fight. If these people just listened to me, this place would be thriving and be improving.
So let's get back to, I want to understand the county's position. So, Ms. Harrison,
Yes.
are you saying that he's allowed to have everything that's in the photos in the backyard, but not beyond 18 inches? Is that what your position is?
It depends.
Okay.
From when I observed the photographs, the overgrowth across the board is such that we cannot distinguish something that should be a shrub and by its very nature is going to be taller than 18 inches versus grass or overgrowth and weeds, which need to be under 18 inches by our code. So anything that is not supposed to be a shrub, or I think you said cabbage palm, those are taller, that's not something we're saying needs to be below 18 inches. But the
So
problem
there are
is,
some species that the county, based on the Florida-friendly landscaping statute, is willing to allow as more than 18 inches, but it's a fact-specific inquiry that you know it when you see it.
the overgrowth at this point is such that we can't tell based on proper maintenance and the right planting in the right places. We can't distinguish it. We can't go in and look at it. We obviously don't have access to his property, so we're looking at it from the outside. Once he cleans out the undergrowth and gets everything back below 18 inches, he can keep
But
it
what
there.
if it's all Florida-friendly? What if every species there is Florida-friendly and
It
it's
needs to be
over-
below 18 inches.
But I thought you said that there is at least some instances where it could be more than 18
I thought you were
inches.
talking about things that were overgrown or the grass being too high. So he can keep everything there. It just has to be properly maintained, and part of that maintenance is staying below 18 inches.
Okay, let me just clarify then. So is there any Florida-friendly flora that the county believes can be greater than 18 inches?
Whatever would be proper maintenance for that plant.
Okay. Now,
So this effectively, again, there's literally Florida native grasses that are supposed to be tall. They're in my yard. If you keep these plants at 18 inches or below, you're effectively outlawing them
Well, I'm reminded
and
of-
meaning that they're going to die.
I'm reminded of a federal case that I've cited in here before about the Audubon Society. And it was in Louisiana, and they were cited for overgrown weeds.
Mhm.
Do you remember that case that I'm talking about?
Vaguely, it's
And
been a little bit.
essentially what the court found was, remember, weeds are undesired plants.
Mm-hmm.
And for the Audubon Society, it's all desired. So it's hard to accuse the Audubon Society of letting, 40 acres of land that's designed to stay natural. It's hard to subject that to a weed restriction. Now, this is not a weed restriction that you have presented. You have presented an overgrown grass case. Is there anyone from the public who wants to be heard? I don't know.
That would be weeds and grass, though, overgrown, for our ordinance.
Well,
The way the ordinance is stated, just so the court's clear, it's weeds, grass, brush, and undergrowth.
I'm
And
aware.
that goes to maintenance.
I'm aware. You have testimony on the record that every plant here is desired.
I understand.
So I don't want to go down, it's not even worth going down that road.
I understand.
I am, sorry guys, I'm going to have to think about it.
Mm-hmm.
I've got to think about it, and I will present a ruling at the next hearing.
Can I? So I don't want to have. I am trying to be mature. Okay. I seek a resolution. I'm not trying to just be maliciously compliant and whatever. Help me to better understand how. Because in that photo, Christian, that quite possibly could be a piece of bamboo. Now, if we're going to call a piece of bamboo an accumulation, brother, the threshold on that is so low that I don't know if it's high enough. Can I just ask you to maybe relook at that photo?
I'm going to issue the order at the next hearing.
Okay.
So I'm not inclined at this point to revisit that. I don't think it's one piece, and I'll leave it there. So
you're sticking to what you said.
I am.
basically.
I am.
I respect it. I'll just be calling code.
So all right, I've got to continue it to the next hearing. I apologize for the inconvenience to both sides. I've got to really think about that one. Okay.
Cool.
Thank you.
Thank you.
Is that going to be mailed or stuck out in my county-owned right-of-way, or how are we doing this?
Well,
October 15th at the Inverness Courthouse.
Okay.
And you're
At
here, so
9
no.
9 a.m.
Are we sure that it's, because I know we're going back and forth.
We're
between-
sure.
October 15th at the Inverness Courthouse.
Okay, cool. What time? 9?
Next case, Anchevali LLC, case number 2025-1214, Code Officer Julie Wilkinson, page 5 of your agenda.
All right. Good afternoon.
Good afternoon.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 25-01214, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 63 South Davis Street in Beverly Hills. The property owner is Anchevali LLC. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on July 22nd and 23rd, 2025. Photos from a corrective action inspection on August 6th, 2025, and photos of my final inspection conducted on September 15th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
All right, these exhibits are admitted as evidence without objection, and I no longer see anyone from the public. Did you take the photos on the dates indicated?
Yes, sir.
Have you had contact with the property owner?
I've had contact with a person who is doing work at the property for the property owner, and I talked to the property owner through the worker's phone.
Oh, really? Okay.
Yes.
And how did that go?
It went well. He told me that they are, redoing the house and they're maintaining it, and the property owner's like, I'm paying this guy, he'll get it all cleaned up. The guy did make a big improvement, yes,
Okay.
thank you. And there's just really, it's minimal. It's just a pile of vegetation with some trash in it that's in the driveway.
Yeah, it doesn't look like much. All right, then what I will do is, what's the county's recommendation?
$50 a day.
Okay, 10 days, $50 a day.
Thank you.
Thank you.
Next case, Lessa Connell, case number 2025-1071, Code Officer Robert Denaro. Page 15 of your agenda.
Good morning.
Good morning, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth? so help you God?
I do.
Thank you.
Good afternoon, everyone.
Please proceed.
Robert Denaro, Citrus County Code Compliance Officer, case number 25-01071, accumulation of junk and debris. Violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6263 East Iona Lane, Inverness, Florida. Property owner, Alessa Connell. Good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during the initial inspection on July 1st, 2025. Corrective action inspection photos on August 1st, 2025. And photos of my final inspection conducted on September 16th, 2025. Exhibit B, a copy of the notice of violation, copy of notice of hearing, a copy of the general pre-order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Okay. I don't see anyone here, so without objection, these documents will be introduced as evidence. Is it Denaro?
Yes.
Okay, thank you very much. All right, we got exhibits A and.
Oh, here's B.
Oh, B. Thank you. And, all right, so I am looking at the photos. Did you take these photos on the
Yes.
dates indicated on them?
Yes, sir.
Okay. And have you had contact with the property owner?
No, I have not.
Have you seen anyone, walking around or living on the property?
No, the only thing I did have a case two cases in regards to overgrown lawn and unlicensed vehicles, which you see on the initial.
I do see it, yeah.
And those were cleaned up, so those were abated.
Okay.
And so the only thing remained was the concluding photos that you see in regards to the accumulation of junk and debris.
Understood. What is your recommendation?
The county recommends $100 a day.
Why aren't
and
you
plus-
recommending that I require injunctive relief for the county to go on and fix it?
Because I did not have that written down on my script, to be quite honest with you.
Well, I'm just giving you a hard time.
Yes,
I always
I
have
see
to
that.
haze someone appearing for the
No,
first
it's okay,
time.
but I was prepared for that.
Okay, good. I had a feeling you would be. So I was trying to think, how can I come up with something new? Unfortunately, I'm running out of
Yeah,
tricks.
yeah.
So, all right. Well, you said $100 a day?
Yes, sir. Plus the administrative cost, of course.
Okay. Then I will find that the property is in violation. I mean, it's still a pretty bad situation, but I will give 15 days to bring it into compliance, and if it's not brought in compliance as ordered, $100 a day.
Thank you, sir.
Thank you.
Next case, William Yosef Albana, case number 2025-1185. Code Officer Robert De Niro, expert on the case Joanna Coutu, page 18 of your agenda.
I'm ready.
Yes, sir, thank you. Robert De Niro, Citrus County Code Compliance Officer, case number 25-01185, special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A.
What do
Address-
you think the legislative intent of this code section is?
My legislative, well, since I'm not a legislator, I'm a county code compliance officer. I basically investigating the nuisance and the code compliance.
That's a heck of an answer. And I appreciate it as a textualist myself. It might be perfect, so good job. All right, I'll let you proceed.
All right.
We're gonna have
As
to
I-
use this for training purposes.
Right,
on how to
right,
get
right,
witness.
right.
Thank you. I set a precedent. Address is 12556 East Walton Drive, Floral City, Florida. Property owner William Yusuf Albana. Good service fire posting of notice of hearing at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during the initial inspection on July 16, 2025. Photos taken during the corrective action inspection on August 1st, 2025. And photos of my final inspection conducted on September 16, 2025. Exhibit B, a copy of the notice of violation, a copy of notice of hearing, a copy of the general hearing order, a photo of the hearing posted at the property, and a copy of the posting affidavit.
Okay.
So,
Then there won't be any objection to that. No one from the public that I see, so we'll admit what's been proposed as Exhibits A and B as evidence without objection, and I'll let you proceed.
Yes, sir. This is a vacant property that is 1.11 acres and is zoned coastal lakes and residential mobile homes allowed. On July 16, 2025, I conducted an initial inspection and observed the recreational vehicle on the property. On July 16, 2025, a notice of violation was issued for special requirements of accessory uses. On August 1st, 2025, I conducted a corrective action inspection and found that the recreational vehicle was has remained on the in the property and remained in violation. Pardon me. I have no contact with the property owner. As of my final inspection, September 16th, the property remains in violation.
Have you had contact with the owner?
No, sir.
What's your recommendation?
$100 a day, along with the administrative cost.
Okay, 7 days, $100 a day.
Yes, sir.
Next case, Magdalena LLC, case number 2025-1231. Code Officer Julie Wilkinson. Yeah, both. They're
Excuse me. This is case number 2501231, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 88 South Adams Street, Beverly Hills. The property owner is Magdalena LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on July 24th. Photos from a corrective action inspection on July 8th. And photos from my final inspection on September 15th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Exhibits A and B are admitted without objection. Did you take the photos on the dates indicated?
Yes, sir.
Contact with the owner?
Contact with the owner, I haven't talked with the owner, but I've spoken with the occupant of the house. And he said he's gonna work on getting it cleaned up. He didn't even know there was a violation because notice goes to the owner, not him, so.
Well, he knew there was a violation.
Well.
And did he say he was gonna clean it up? What was the date of that conversation?
That was when I was there doing my final inspection. He actually pulled up while I
2
was
days
doing the
ago?
inspection, yeah. He did send me some photos in an email this morning with tarps over everything, and I told him that that does not abate the violation, so.
Okay. Okay. Where does this rate on the junk scale?
For Citrus County,
That's what we're talking about. Yes.
like a 3 or a 4. A 4, yeah.
I mean, I guess based on the quantity, I don't, based on the appearance, I'm not so sure. It's just, it's gathered.
Yeah.
I'm gonna put it at a 3. Nonetheless, what's the county's recommendation?
$100 a day.
Okay, 15 days, $100 a day.
Thank you.
Thank you.
Next case, Mariah Rosati, case number 2025-1098, Code Officer Julie Wilkinson. Oh, did I miss?
Did we miss Travis Mitchell?
Oh, wow.
Okay.
Well, we'll catch him next.
Okay.
My bad.
I thought maybe I missed something.
No, no.
Where are we going?
Rosati.
Rosati, okay.
I missed Minstrel.
This is case number 25-01098, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 3201 North Tamarisk Avenue, Beverly Hills. Property owner is Maria Rosati. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on July 8th, 2025. Photos from a corrective action inspection on July 23, 2025. Photos from a final inspection conducted on September 15th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
What's been proposed as Exhibits A and B are admitted as evidence without objection. Thank you. Are there any native Florida flora here?
Oh, I wasn't paying attention to that, but the lawn is overgrown, so in that,
Does it matter?
yeah, I
mean,
think
if-
it does matter.
If the grass is native Florida flora, which the Florida legislature has indicated an intent to foster and to exempt from the application of the Citrus County Code, then why wouldn't it matter?
Because it's a lawn, it's not
Because
an
it still
ornamental
has- It
grass.
still has to be maintained below 18 inches. If they want to cut it at 17
It's an
and a half,
interesting
they
position. It's an interesting position. We're gonna find out, you know. I don't know what's gonna happen, but it's kind of like Florida drivers. When they're driving, especially I might say in the Sarasota area, I don't think even they know where they're going. Like they grip the wheel especially hard just because they are surprised. Like they'll find the car turning left and even they're surprised by the direction they're going. And it's really interesting. All right, so you took the photos on the dates indicated.
Yes, sir.
Have you had contact with the property owner?
No, I have not.
Or the person in possession or a tenant or anything?
No, the house appears vacant.
Just curious, so the first photos here are July 8th. So is the normal time from the beginning of an investigation, you like give it some time, do a reinspection, is it still there? And then like in the pipeline of cases, it comes 2 months later, 2.5?
No, well, typically, we'll do an inspection, and usually it's 2 weeks. We'll go back and do the corrective action inspection. However, this is, it ends up being about 2 months before it makes it to special master hearing.
Yeah, okay, I was just curious. What's the county's recommendation?
$100 a day.
Okay, 10 days, $100 a day.
Thank you.
All right, Travis R. Mitchell, case number 2025-1178, Code Officer Julie Wilkinson, page 24 of your agenda.
Case number 2501178, unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 39 South Harrison Street in Beverly Hills. The property owner is Travis R. Mitchell. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on July 18th, 2025, photos from a corrective action inspection on July 5th, 2025, and photos of my final inspection conducted on September 15th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photos of the notice of hearing posted at the property, and a copy of the posting affidavit.
Without objection, Exhibits A and B are evidence. Thank you. All right, tell me about this case.
So it's an unlicensed vehicle on the property. I did have contact with Mr. Mitchell, the property owner, yesterday, and he did say he's selling the truck and he should be able to get it gone in 3 weeks.
All right, what's the county's recommendation?
$100 a day.
10 days, $100 a day.
Thank you.
Last case, Stephen Todd Walker, case number 2025-897, Code Officer Cody McGuire, page 30 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Ready?
Yes.
All right. Cody McGuire, Citrus County Code Compliance Officer, case number 2025-00897, a violation of the Citrus County Land Development Code, Section 4002, site development without a development order or permit. Address is 5859 North Suncoast Boulevard, Christopher, Florida. It is 1.13 acres and it is zoned RUR. The property owner is Stephen Todd Walker. Goods service via signed certified mail return receipt and posting at the Canto Government Building. And I'd like to authenticate the following documents and request they be admitted in evidence. Is Exhibit A, photos I took during the initial inspection on June 5th, 2025. Posting a stop work order on June 11th, 2025. A corrective action inspection on July 21st, 2025. And photos of my pre-hearing inspection on September 15th, 2025. And then aerials dated June 20th, 2025 and July 16th, 2025. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipts, and a general pre-hearing order.
Okay. Exhibits A and B are admitted as evidence. Thank you. Go ahead.
Okay. I conducted initial inspection on June 5th, 2025, and observed property had trees removed and groundwork done. A notice of violation was issued for site modification, which is a violation of the ordinance listed above. While researching the property, I observed that there were no permits applied for or issued. On June 11th, my director and I posted a stop work order on the property due to it being in a flood zone. On July 21st, a corrective action inspection was conducted, and there were workers currently on the property after the work order was posted, and more materials, including fill, were brought in, which led to our office being flooded with calls. After we got back from that inspection, I had relooked for a permit, and one had been applied for. As of my final inspection on September 15th, 2025, the permit's still been applied for and has not been issued.
Have you had contact with the property owner or any contractor on the site?
The only contact I've had with the property owner was during last month's hearing when he had an attorney present with him.
Which hearing was?
The fence was too high.
Yep, that was the barbed wire fence.
The barbed wire.
That they stated they put there to protect the materials that were on the
remember
property.
that. And I gave them a certain time to comply. They didn't like the time. I'm remembering. I didn't think that was the name of the owner, but normally I recognize it. So it's the same owner?
Yes, sir.
Okay. Why aren't they here?
I haven't spoken with them since that day.
Site modification. Did they know, at the time you brought that case, did they know this case was pending? I mean, they had to because of the stop work order, right?
can only assume.
Well, they did know about it at the,
Right.
at the last month's hearing also, because we had to explain why the cases was kind of put on different ones during the time.
Well, that's a
frame.
good question. Why was it?
I believe the time frame from when they put the fence up and he seen the violation, so the fence would have been a shorter time, you know, to get it on the hearing, because you can get that resolved in a couple of weeks or a week.
Okay. Ms. Katu, do you have any testimony?
Just that they did apply for a single-family residence as an owner-builder on June 26th. It was denied on July 7th by all parties. There was not any real plans submitted, and there's been no activity since July 7th on the permit.
Is this a county road?
It's US 19.
Oh, it's US 19.
Yeah.
It looks like a big road. That's why I'm asking.
Yeah, it is. It just happens to be residential zoning, which we have on 19 outside.
It's
of
residential?
commercial. Yeah.
So they can just put like one house on there? Wow.
Yeah, they can.
Okay, well, good, property rights. Those are nice trees.
I think there's only one left.
What?
Yeah, they-
Inside the fence?
Yes, if you look at the aerial from the property appraiser's website,
They
you can,
completely
it's like,
cleared it.
it's completely cleared. It looks like maybe,
So
if we're being generous, maybe 2 trees.
do you have other cases pending?
On this address?
Yeah.
Just the fence.
Just the fence violation?
Well, didn't I resolve
Well,
that?
you-
Oh, okay, all right.
They didn't abate it.
I haven't done it yet.
What's the county's recommendation?
Due to the nature of this violation, the Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $15,000 along with administrative costs.
Do I have authority to do that?
Yes.
I can go up to 15,000?
Yes, sir.
Can you show me the code? I thought I could only go up to 10,000.
Please hold. Let me-
19. Him too.
Under 15 dash, or 19 dash 55,
55.
Subsection E, if the code compliance special master finds the violation is irreparable and irreversible in nature, he may impose a fine not to exceed $15,000 per violation.
Okay, well, what from the county's perspective here is irreparable?
Everything done without a permit.
I'm sorry, everything done without a permit? Put something on the record, please.
May I ask him some questions?
Yeah.
You indicated in your testimony that the removal of the trees was part of the site modification, is that correct?
Correct.
Are they able to put the trees back up?
No.
You indicated that the land clearing, grading, and fill being brought in were part of your violation, is that correct?
Correct, and then continued.
And then it continued. Is it possible, to your knowledge, to put the land back in the original form it was in before all of this work started?
No.
If you are
It would take
unable-
time.
If you are unable to put something back to the way it was originally, is it irreparable and irreversible?
Correct.
You know, I'm just speaking academically here. The thing about a one-time fine, whether it's 10,000, 5,000, 15,000, is that it may actually end up being less than what they'd incur on a daily fine, you know, depending on how I exercise it. So I think that's something the county should think about in the future. I'm not encouraging the county to just go out and get that kind of thing. But anyways, I will find that the damage is irreparable based on the testimony here at the hearing. I'll assess a $10,000 fine. The reason I'm going 10 instead of 15 is because there are examples of worse things that I can see that would require a $15,000 fine instead of a $10,000 fine.
Yes, sir.
Although I do find that this is a bad case. And that's it.
Thank you, Your Honor.
Thank you. Is that the last case?
Yes, sir.
I do have a question before we adjourn. It is, do you find that the pre-hearing order has done anything for you all? Is it of a benefit, or is it more of a nuisance to just send out?
In rare circumstances, it is read by the respondent.
It does help when they hire an attorney.
Yeah.
I found that is.
Because they reach out to you, or?
Either the attorney reaches out to me or it prepares the attorney for what to expect in your proceedings. So when the attorney calls me, they have a few less questions.
Well, and also if they appeal because they claim they couldn't.
Right.
Show
You got
that,
the order,
oh,
yeah.
You got the order.
I think it's still relevant for giving, so they know what I expect. So, okay, just good to know. Is there anything else?
Next month, Inverness.
I'm sorry?
We're in
next
Inverness.
month,
Inverness.
October
All right,
is Inverness.
time is 12:30. This hearing is adjourned.